to the Polytechnic University of the Philippines. The Polytechnic University of the Philippines is a government higher educational institution governed by Republic Act No. 8292, known as the Higher Education Modernization Act of 1997, and its implementing rules and regulations contained in the Commission on Higher Education Memorandum Circular No. 4, Series of 1997. PUP was established in 1904 as Manila Business School. In 1908, it was renamed as Philippine School of Commerce or PSC and merged with Philippine Normal School from 1936 to 1946. Through the virtue of Republic Act 778, PSC was renamed to Philippine College of Commerce or PCC in 1952. On April 1, 1978, PCC was converted into the Chartered State University, now known as the Polytechnic University of the Philippines, by virtue of Presidential Decree No. 1341, issued by the President of the Republic of the Philippines. For more than 100 years, PUP has been a partner of the government in providing quality, globally competitive, and industry-responsive education to bright, deserving students.
Pinakamura ang matrikula sa PUP.
Pinakamababang tuition sa buong bansa, 12 pesos kada unit.
With the lowest tuition for tertiary education, qualified faculty members, efficient administrative staff, goal-oriented leaders, and industry-responsive curricula that is at par with international standards, PUP has earned a reputation of one of the country's top higher education institutions. As an epistemic community, PUP is consistent with its commitment to produce quality graduates in various fields of specialization, working toward its goal of becoming the first national polytechnic university in the country. With 22 branches and campuses spread across Luzon, serving more than 70,000 students, the Polytechnic University of the Philippines offers more than 80 programs in the graduate and undergraduate levels. It also offers distance learning through the Open University system, technical and professional programs in the area of business and distributive arts, education and the social sciences related to the fields of commerce, business administration, and other polytechnic areas. The commitment of its leadership, faculty, staff, students, alumni, and partners has formed the cornerstone of this university that has exceeded expectations with every generation of the graduates it has produced since its establishment. Today, PUP has gone far from what it was more than a century ago, but what remains is PUP's mission to continue to be the government's partner in nation building and in poverty alleviation of the marginalized sector of society. With quality, responsive, and relevant education as a tool. PUP, the first polytechnic university.
Emerson is a global technology and engineering leader. We operate in over 150 countries. We are 110,000 employees worldwide. And here in the Philippines, we have over 2,000 employees.
My name is Vicky Florento. I'm from Dell Philippines. I'm handling the university relations and services hiring.
Pagasa Steel supplies concrete reinforcing bars to the Philippines' booming construction industry. We have been the leading supplier of quality steel bars for the past 52 years.
EGS is an Alborica company. It is one of the fastest growing BPO companies in the Philippines right now.
I'm Cecil Venancia and I'm Branding and Communications Director of Sykes Asia.
We don't decide whether you're from a top-tier university or a state university. We decide based on our assessments that includes exams and interviews. Having said that, a lot of Dell's workforce in the Philippines are from PUP.
55 to 80 hires annually, those coming from PUP alone. And as a matter of fact, 14 of the homegrown employees who started from staff and supervisors have been promoted.
Currently, we have 13 employees from the PUP. They're working in a different field, so most of them are engineer, some are in sales, most of them are in the higher position.
There's a huge pool of students that we can really harvest from. And we know the reputation that they bring. So we're glad that we have a university like PUP that we can rely on for our future employees.
I love the graduates of PUP. They're not only fun to work with, but you can rely on them. They are very, very dependable.
PUP graduates are an exact match and fit to Pagasa Steel's mission and vision.
The reason why we prefer the PUP graduates is the fact that we noticed that they have a common denominator, very hardworking. You see, whatever happens, they'd still work. Even if it's raining, they'd still come to work. You give them additional tasks, they'd accept. They are resilient.
Very passionate, aside from being resilient, because we can see that they're very dedicated with their job. And we've seen a lot of PUP graduates, not just in one department.
They turn out to adapt very well and adjust well to our company here in the Philippines. They're productive employees and they stay with us for a long time.
Stand out sa PUP graduate is their loyalty sa company.
Integrity and ethics, drive for results, intellectual capacity, and adaptability. So when we hire PUPians, they have this kind of competencies.
Of course, they're very intelligent people, responsible. Responsible in a sense because whenever we meet these graduates and we ask them what are their future plans, they would always come up with answers like helping out their family, or because I'm done with school, I'll help out another sibling. So you would know already that these kids, even before they actually embark on certain work, they already have goals in mind.
They're not maarte, no? Whatever you give them, they know that if it's for the purpose of the job, they will do it. And so they have, they're the ones that survive the challenges of work. They don't shirk away from responsibilities. They're the type who, whatever the job requires, they're up for the challenge.
PUPians enable people everywhere to grow and thrive.
PUP is one of the pillars of the nation because it is an institution that provides good graduates and people who really contribute to the success of the community or to the success of the country.
To all the people associated with PUP, if you're a graduate, congratulations, and you should be proud of yourselves. For those of you that are students, please continue the tradition, the proud legacy that your school has. Some of you, PUP, you work for us now. We appreciate you. We know you're good employees. For those of you that might work for us in the future, please consider us. We'd love to have you. We know that you make a great employee for Emerson.
PUPians, bring everything you are. If you have big ideas, let's talk. Come work where passion meets possibility. You can visit jobs.del.com for opportunities.
To pursue your dreams and work hard for whatever endeavor you will choose. And in the event that you will choose to apply in one of the fastest BPO companies in the Philippines, I would like to invite you to apply in EGS, an Alorica company, because our doors are open for all of you.
To all the PUPians, let's create a Science of Smile together.
SMART is very happy to have PUP graduates now enjoying their career and let them live more.
Hashtag Sites to PUP. We will support you in more ways than one.
Tara na, maging magkasama na tayo. Mabuhay ang PUP!
Isang magandang Isang magandang tanghali sa ating mga kaisko at kaiska na nandito ngayon. So, magandang tanghali po sa inyong lahat at sa ating mga estudyante. Actually, mula sa College of Business Administration, Open University, College of Political Science and Administration, College of Social Sciences and Development, at syempre, meron din po tayong mga estudyante or mga nakikinig na hindi from PUP lang. So, syempre, yung mga nakaantabay, magandang tanghali po sa inyong lahat. So, I'm Professor Jane S. Pulma of the Alumni Relation and Career Development Office, and I will be your moderator for today's event. So, the role of our office, the Alumni Relation and Career Development Office, provides services not just to the student, but also to the alumni, in support to the area of career development and placement, and we also sustain the link between the academe and industry. So this topic, labor law, medyo mainit po siya, di ba? So I hope na lahat ng matutunan nyo, yung knowledge, skills, and abilities na pwede nyong matutunan at mahon, is makatulong sa inyo hindi lang personally but also professionally. Marami tayong i-discuss mamaya. So, andito, actually 5 araw tayong magdi-discuss po mamaya. Meron tayong sunod-sunod na session para lang sa labor law. So, ano ba yung labor standard? Pag sinabi nating labor standard, normally, ito yung mga legally mandated benefits na nire-require ng isang empleyado sa kanyang employer. Pero in case na hindi kayo nasa private, pwede din naman ang government. So, in summary, yung mga legal mandates ng benefits na yun is required para sa empleyado at para makapag-benefit sa atin. So, syempre, dito nakasama yung mga i-discuss natin, yung mga labor and social legislation, legal Okay. So, syempre, i-discuss din natin mamaya yung mga legal rights of a worker, mga management prerogative, existence ng employer-employee relationship, classification of worker, syempre, yung mga health, safety, and social welfare benefits, just causes ng ating termination, unfair labor practices, strike, labor standard, or settlement ng labor dispute, at syempre, ito yung pinakamahalaga, yung wage and wage-related benefits. Siyempre, di ba? Nagtatrabaho tayo. Siyempre, kailangan at importante diyang malaman natin kung magkano at tama ba yung pinasusweldo at ano-ano ba yung mga karapatan ng bawat isa. Okay, so let me discuss first our webinar etiquette. Okay, may 2 po tayong participants for today's event. Our Zoom participants, kayo po yon. Welcome po sa ating online labor law and standard review and course. So, please remember that this webinar is currently on live, and remember to always keep your microphone always on mute. You can interact with our speaker po. You may raise your hand or pwede nyo rin naman pong gamitin ang ating Zoom chat. So, pwede po kayong mag-participate sa ating speaker at pwede kayong magbigay ng comment and suggestion, question nyo through our Zoom chat po. Next one, para naman sa ating stream participants. So, sino ba yun? Siyempre, hindi natin pwedeng kalimutan ng ating mga nanonood at nakaantabay sa ating PUP Career Center Facebook page. Pwede po kayong maki-interact sa ating speaker at sa ating live na to sa pamagitan ng pag-iiwan ng comment, question, at suggestion. And kung halimbawa meron man kayong feedback na pwedeng ibigay, pwede nyo po yung ilagay sa comment section ng ating live. You just have to introduce yourself with your course year and section. Gagamitin po natin yon kung meron po tayong sa Q&A portion. So para po sa lahat, makaka-receive po kayo ng digital certificate that will be release 2 to 3 weeks after the conduct of this webinar. Dahil meron po tayong 5 session, 5 certificate po yung matatanggap nyo mula sa amin. So everyday po, meron po kayo, every meeting po natin, meron po kayong set of evaluation at per meeting po yun ay may equivalent number of hours. I hope na yung matututunan nyo ngayong araw na to is makatulong sa inyo, lalo na yung mga aspiring na human resource associate, di ba? At sa mga nagtatrabaho naman po at future na magtatrabaho, sana makatulong ito para mabigyan kayo ng higit na kaalaman kung papaano maging mabuting empleyado at paano naman syempre yung mga responsibilities ng employer ay alam nyong nakikarry out sa inyo properly. So hindi ko na po patatagalin. Let me introduce our speaker for today's event. Okay. Our speaker is a graduate of the University of Santo Tomas, Faculty of Civil Law in Manila. He was admitted to Philippine Bar in 2004 and the 6th year as lawyer, he founded the Gargantiel Law Office. It was just a law office then, and now it was a small-size, full-service law office known as the Gargantiel, Ilagan, Amanante, or Gia Law. So, Attorney Chris is a legal counsel of a leading broadcast sheet and publishing corporation in the country, non-governmental organization and organization from business process outsourcing, real estate development, and software development industry. He assisted them in the corporate, labor, tax matter, and litigation cases. He is a dedicated and excellent litigator. His subordinate and colleague alike seek his insight and guidelines when they face a noble and complex legal issue. So he earned praises and respect not just sa colleague niya, but also sa kanyang kliyente and opposing counsel. So, while known to be a top caliber litigator, Attorney Chris is also an academician. So, he teaches criminal law sa pamantasan ng lungsod ng Manila, College of Law, and administrative law, law of public officer, election law, and public corporation at the University of Santo Tomas, Faculty of Civil Law. So, syempre, si Attorney Chris, nagle-lecture siya hindi lang ng criminal law, public corporation, which is ginagawa niya yon sa MCLE or sa Mandatory Continuing Legal Education for Lawyer. So, for more than a decade, he also taught obligation and contract, corporation law, labor law, constitutional law, person and family relation, partnership, agency and sales, negotiable instrument, bago pa po siya magturo sa UST at PLM. He was also a faculty and a professor from the University of Makati and the PUP Manila. So, in PUP, he also served as the University Legal Counsel, and he also served as the member of the Board of Directors of the Quezon City Chapter of the Integrated Bar of the Philippines, or IBPQC, and a volunteer lawyer and its legal team. So, Attorney Chris is a resource speaker in various law-oriented webinar on social media, program, not just in radio, but also in the national television. So from 2018 to 2023, he is a member of the board of the director of the DBP Data Center Incorporation, the only government corporation and control corporation which mandated to provide IT services, and he briefly served as the assistant secretary in the office of the Senior Deputy Executive Secretary of the Office of the President in Malacanang. So, Attorney Chris is one of the Asia Business Law Journal top 100 lawyer in the Philippines for the year 2020, 2021, 2022, 2023, and 2024. So guys, 5 years na po siyang nasa top 100 lawyer in the Philippines. He is currently the second nominee of EDOC Action Party List and one of the party list organization that advocates educational reform with a specific and well-defined program. So guys, ganun po kabigatin ang ating speaker. So, without any further ado guys, baka pwede naman isang masigabong virtual clap para kay Attorney Chris John Garganchel.
Thank you, Professor Pulma, and thank you for having me here. I will always look forward to lecturing or speaking to my former colleagues, so PUP. I would like to also greet University President Dr. Manuel Muhi. So, matagal ko nang kakilala si President Muhi noong ako ay nagtrabaho bilang isa sa mga abogado ng PUP, University Legal Counsel's Office. Panahon pa yan ni President Ibarra. Nakilala ko si President Muhi nung panahon na yan. Siya ay ang dekana, ang dean ng College of Engineering. So I'm happy, I'm thrilled that after a few years, si Dean Muhi ay ngayon ay pangulo na ng ating pamantasan, Polytechnic University of the Philippines. I would also like to greet and thank Dr. Florinda Oquindo for choosing me as the speaker for the said topic. At saka I would like to give my regards to Jope. Andiyan ba si Jope ngayon, ma'am?
Yes, sir. Nandito po si Miss Jope. Nakikinig po siya sa inyo.
Alright, that's good. So may prepare ako na, so I know if it's just me speaking the entire afternoon, even though the topic may be interesting to most of us here, it's gonna get boring eventually. So I prepared some slides. So I'll just be sharing the screen. I hope you see the slides. Do you? Right? Yeah. Can anyone give me a thumbs up so that I can confirm, because you are all on mute? There. Okay. Yeah. So nakita ko nag-raise ng hand si Russell Bon. So, and then let me just fix the gallery so that I can see the persons I'm talking to. You're not turning off your camera, so that's fine. That's fine. It's because poor connectivity, baka maputol kapag nag-on kayo ng video. But if mataas ang connection nyo, I'd appreciate if you can turn on. I'd appreciate if you turn on your video so that kapag merong umiiling nakasimangot, conscious kasi ako pagka hindi kailangan makita ko yung reaction kagaya niyan, no? Nag-on na si Juan Roliza, yan, taga BSBA-HRM. Yan, di ba? Yan. Yan! Yan sinasabi ko sa inyo, on nyo, kung hindi naman malalagot ang ating connection, Ma'am Pulma, no? Kapag nag-on sila lahat, kaya-kaya ng connection ng PUP yan.
Kaya naman, sir.
Ayun. Great. Awesome. So you can see in your screens right now, the topic that we have here, it's labor law and social legislation. That's one of the topics. And it's followed by workers' rights and management prerogatives. As mentioned by Professor Pulma earlier, this would be a series of career development talks that concentrate on labor laws. But since labor is a broad subject, it's extensive, and in the College of Law where I came from, College of Law, 3 semesters na pinag-aaralan ng labor law. So you could just imagine the magnitude, the extent. And for us, it's gonna be challenging to compress it into 5 lectures. So you will be expecting that there may be some topics here that we will not be able to cover at the first time on the first meeting, but eventually in the subsequent sessions that we are going to have, we might be able to touch them. Now, you would also have to understand that since we're not most of us here, while most of us may be alumni of PUP, nagtatrabaho na, we would only concentrate on the basic principles, basic laws, the things that you need to know out there pag nagtatrabaho kayo. Hindi naman kasi ninyo kailangan malaman yung nitty-gritty or yung technicalities sa labor laws. Let's leave that to the lawyers. Let's discuss on a need-to-know basis. Ano ba ang kailangan nyo na para hindi kayo nagtitake na advantage ang mga employers niyo. So you know what your rights are and you know what the management prerogatives are. You know where you stand. So we will concentrate on basic principles. So you might feel the need to ask something technical. I'll do my best later on to answer your questions. But please understand that I might tell you that we have to reserve some of your topics for the subsequent lectures. 5 yan actually. So starting this Monday, for the next 4 Mondays pa, you'd be seeing my face again. Same time, same channel, 3 hours. 3 hours. Now, you see, just to emphasize, we have the slide now. So this is the topic. These are the topics. So the first is labor and social legislation and legal rights of workers and management prerogatives. So I took this is the invitation. I took that from the invitation letter of the Alumni Relations and Career Development Office. And at first I was overwhelmed. Parang hindi ako nakatanggi. Ang dami. 3 oras, 5 beses. 5 Lunes na magkakasunod. So parang bar review yata ito sa bar exam pinagagawa sa akin la Jope at sa kanila Ma'am Kindo. Pero at any rate, it's my pleasure to see you again, ang mga taga Polytechnic University of the Philippines, and long time. And siyempre, who am I to refuse? It's a great honor to be chosen as the speaker or lecturer for today. So you will see labor and social legislation. Ito yan. No? Nakikita niya, nagdo-drawing ako. No? Yan. Kita niyo, draw yan. And then next week, November 18, yung pagdating sa mga minimum wage at saka yung mga overtime, night shift differential, holiday pay, diyan natin pag-aaralan yan. After that, the following week, November 25, pagdating sa mga sibakan, tanggalan, dismissals, or constructive dismissals. So termination, burden of proof, we'll be discussing that on November 25, same time. 1:30 to 4:30. And then on December 2, pang-apat is the labor organizations, representation issues, collective bargaining concepts, so on and so forth. So ito yung mga union. Ito yung mga strike. So saan ba pwedeng magkaroon ng union? Lahat ba ng kumpanya ay may union? Kapag ba ang lugawan dyan sa bandang Welcome Rotonda, magtatayo ng union yung mga kusinero at saka yung mga tagahiwa ng sibuyas. Pwede ba yun? No? O halimbawa, ang security agency ba na nagkikater sa mga malls, pwede ba silang magtayo ng union? Ang mga ating mga kawani sa pamahalaan, pwede ba silang magtayo ng union? At kung pwede ba silang mag-strike? Yan ay susubukan nating sagutin sa December 2, 2024. And then December 9, pinakahuli, is yung unfair labor practices, strikes, picketing, and lockouts. So, medyo extensive ko kasi mga mahal kong guro at mga estudyante sa PUP. Medyo extensive ho ang labor relations. Itong part na to, labor relations ho yan. Medyo extensive yan. Mag-spill over po yan. Yung December 2 natin, mag-spill over yan sa December 9. So they are related. They are closely related. All of them actually are closely related. But you will see later on that labor law is divided into a lot of fields, a lot of topics, and I'll tell you about it in a few minutes. Now, when we say labor law, ang talagang pinoprotektahan yan, ang concern dyan, ay yung, the name speaks for itself, laborer. Sa Tagalog, manggagawa. manggagawa. Pero ganun pa man, no? Ang proteksyon na ibinibigay ng ating batas para sa uring manggagawa ay hindi lamang talaga sa literal na manggagawa na nakagawian nating tawagin ng those who perform blue-collar jobs. So it also extends to other kinds of employees. Now, when we say labor kasi, this one, labor, it's broad. It's we understand it to be in something that involves physical toil, although it may not necessarily include the application of skills or knowledge. So physical, that's part of labor. But you see, for purposes of discussion, when we say labor law, it also extends to those activities, employee activities, where it's not only limited to physical skills or skills involved. Pag sinabi kasi nating skills, it's the knowledge or familiarity of any art or science, or it's actually the use or the application of an art or a science to practical purposes. Yun ang skill. So pagsama welding, speaking, writing, paglikha ng mga digital arts. So those are skills. Pero pag sinabi kasi natin na work, kanina labor yan eh. Labor, it's understood as physical toil. It does not necessarily exclude the application of skill, but it also cover the concept of work. So it's broad, wider ang activities na cover ng work. Pwedeng physical, pwede ring intellectual. So kung ikaw ay for example, ikaw ay mamamahayag, journalist, no? So that's intellectual. Hindi ka naman nagbubuhat, hindi naman physical ang trabaho, no? So intellectual yan. So covered yun ng work. So madaling salita, ang labor, pasok din siya sa concept ng work. Kasi nga, ang labor, traditional meaning niyan, physical or manual work. Pero despite the difference, hindi siya balakid para maintindihan natin or para ma-appreciate natin na yung dalawang konsepto na yan, labor at saka work, they pertain to employment and the rights of obligations of employers and employees. So, huwag kayong mag-alala. Hindi porke naku po, ang trabaho ko ay pang matalino. Pang matalino ang trabaho ko, hindi na ako covered ng labor code. Hala. Hindi ganun ho yun. Hindi ho ganun. No? So whether it's labor, work, intellectual tasks or skills, you don't have to worry. It's still covered by labor code. So, ito pa isa. Meron din sa mapapasadahan, no? Yung worker at saka employee. Magkaiba ba yan? Okay. Ang worker, it's broad. Mas broad din yan. Kagaya kung paano ko sinabi ang work ay broad, ganun din ang worker. Kasi siya nga nag-work, worker siya. A worker, however, is broad, so it may refer to those who are self-employed and those who are working the service or under the control of another. So, self-employed, an example of a person who is self-employed is myself. So, I have a law firm. I'm practicing in my law office, my law firm, so I can call myself self-employed. But at the same time, I am an employee. Why is that? Because I teach at the University of Santo Tomas. I currently teach at the Pamantasan ng Lungsod ng Maynila. As an employee, I am a salaried person who works for another, who controls and supervises the means, the manner, and the methods of my work. So that makes me an employee. But for purposes of the labor code, ang concentration talaga, more often than not, sa labor code, this time, pagdating sa dalawa na to, ay empleyado. No? Yung mga proteksyon na ilinalaan ng labor code, yung mga management prerogatives, employees' rights, totoo naman na ito ay napapakinabangan o ito ay para sa proteksyon ng worker. But strictly speaking, since worker may also refer to self-employed people, it's best to state or to refer to them as employees. You follow me so far? All right. Yes. That's the reason why I wanted you to turn on your cameras, because I wanted you to shake your head or to nod if there's something wrong. That's fine. If you have to do something private, Don't forget to turn off your video, however. All right? Because number one, we're live on Facebook, and number two, it's being recorded. So you don't want to catch yourself doing something uncompromising or whatever. All right? Now, since we're speaking of labor law, it's also important for us to realize what the nature of labor law is. So we mentioned it protects si manggagawa. Now, that being said, labor law is a kind of social legislation. Bakit siya legislation? Kasi batas yan eh. Batas yan. You remember we have 3 branches of government. We have the executive department, judiciary, we have the legislative department. Executive is in charge of the implementation or the execution of laws. Judiciary, on the other hand, it interprets the law. Now, legislation is the power of the purse. It's the only branch of the government authorized to enact to create laws. So, part of enjoying democracy, the part of balancing the power is to make sure that these 3 duties, these 3 responsibilities are carried out by an independent, separate branch of government. Otherwise, in the same manner that we do not want persons or agencies or offices to be the judge, jury, and executioner at the same time, hindi rin pwede na sa iisang branch ng government, siya ang entitled na o siya ang may mandato na maggawa ng batas at i-implement ang batas at the same time mag-interpret. Patay tayo doon pag gano'n na nangyari. So, ang social legislation, batas yan, gawa ng Kongreso, gawa ng Senado. At ang tinututukan yan ay yung mga proteksyon at mga benepisyo, society or segments thereof in furtherance of social justice. Okay. So, social justice. So, pag social justice para sa lahat yan. For the benefit of society or the segments thereof. So that being said, since it's for the protection, for the benefits, you will see later on, and I will demonstrate to you in a couple of hours, that labor laws are necessarily social legislation. Okay, but however, take note. We understand there may be some shortcomings, there may be some perception that it's not sufficient protection given to laborers, or that it's not necessarily reflective of what is happening actually, no? But still, nevertheless, the principle is that when we speak of labor laws, the intent there, although you might argue that it's not fully realized, is that labor laws are intended for social justice and therefore it's social legislation. So that being said, you will expect that more often than not, I'll discuss that to you later. Ang labor laws, medyo nakatilt yan, madalas sa hindi, in favor of the employee. Madalas sa hindi, nakatilt. Siyempre, hindi naman lagi di ba? Parang yung naalala niyo yung may joke na nagpunta sila ng Spain, nanood sila ng bullfight, nagutom sila dahil next site, umorder sila ng soup number 5. Malaki yung soup, yung laman, kasi yun yung mga bull na natatalo sa bullfighting. So nawili sila, bumalik sila kinabukasan, nagtanong sila, order ulit sila ng soup number 5. Maliit yung laman ng soup. So tinanong nila in Spanish, bakit lumiit yung soup? Ang sagot sa kanila, kasi pardon me senyor, kasi yung bullfight, hindi ho laging yung bull ang natatalo. So anyway, so ganun din sa labor law. So sa labor law, hindi laging in favor of the employee, but still the tendency is, the inclination is always in favor of the employee. Social legislation. Now, labor law is, well, it can be divided into 2. We have labor standards and labor relations. So pag sinabing sa labor law, while it's a part of social legislation, it's the system, statutes, regulations that govern relations between capital and labor. Capital and labor. Marami ho kasing sabog yan, kalat yan. Marami ang social legislation. Pero pagdating sa relationship, capital or employers on the one hand at ang uring manggagawa or laborers on the other, labor law ang nakatoka doon. So dahil sa labor law, meron tayong mga employment standards. It provides for a legal framework. So negotiation, adjustment, administration of those standards and other incidents of employment. Yun na nga yung kaninang pinakita ko po sa inyo, mga mahal na taga-subaybay, mga estudyante, mga guro ng ating pamantasan. Ito ho yun. Yan ang labor law. Okay. Now, let's go back. I mentioned to you, labor law can be divided into labor standards and labor relations. So we have labor standards, we have labor relations. Ano labor standards? The definition is there. And I know it's gonna be boring if I do the entire afternoon. I'll just be reading what is being shown in the slide. I know you do not want that to happen. Now, when we speak of labor standards, it prescribes the minimum requirements. Kaya nga tinatawag siya na standard. Parang yan kung ikaw ay maghahanap ng girlfriend or boyfriend, hindi lahat 'di ba? Parang ano bang dating app ngayon? Sorry, old age ano bang mga dating app? 'Di ba may mga swipe left, swipe right pa yan yung mga ganyan. So hindi mo Tinder, ang galing, updated si Ma'am Pulma, updated siya, updated. So, hindi lahat swipe left, hindi lahat swipe right kasi you have standards, may requisitos ka na you do not want to go below that standard. Ganon din sa labor, meron siyang tinatawag na labor standards. Ibig sabihin, pag sinet ng batas, kasi di ba nga labor law siya, di ba? Labor law, social legislation siya. Pag sinet ng batas yung standard, hindi pwede na i-expose ang empleyado beneath or below the imposed standard. So dahil dyan, mayroong mga minimum requirements na pinaprescribe ng batas. Yan ho ay hindi sinasabi, dinidikta ng kung sino lang na mananalo tuwing eleksyon. Ang nagdidikta niyan yung batas na ipinasa ng Kongreso. So it's prescribed by existing laws. At minsan, dahil inaatasan, it's also possible that the legislative department authorizes agencies like the Department of Labor and Employment to implement, pwede silang mag-issue ng rules and regulations, ang DOLE, in further implementing what was already legislated. Yun lamang sa labor standards, yung mga labor standards law like minimum wage, although ini-implement yan through rules and regulations or circulars, hindi dapat tataliwas ang rules and regulations at circulars doon sa mga standards na inimpose na sa batas na yon. So example, yung wages. We have minimum wage. Ngayon, paano nagkaroon ho ng batas? Ang naalala ko na nag-i-impose po niyan ay, pwedeng tatanong nyo na gano'n ay Regional Tripartite Wage and Productivity Board na meron tayo for every region. We have here in NCR, we have there in Region 1, 2, 3, and so on and so forth. You see, it's an example of what I mentioned earlier. It's a delegated legislative power. Congress, through the Labor Code, set the standards. Now, it's for the Department of Labor to follow those standards in coming up with the recommended minimum wage for each region. So sa aking pagkakaalam ngayon sa National Capital Region where the prescribed minimum wage rate is the highest, it's 650 pesos per day. It's 650 pesos per day. Now it might not sit well with some or most of us. It may be argued that it's insufficient and that is respectable. We can take note of that because ang hirap 650 pesos per day. 200 pesos pinangtitip nyo pa lang sa Grab rider yan pag nagpa-deliver kayo sa Shopee or sa anuman 'di ba? So baring bitin. Pero take note guys, yung 650, yun ang minimum. So doon papasok ngayon yung pagiging competitive din ng mga employers since they wanted to hire individuals like you. And take note, sa survey yata ang PUP daw ang pinaka number one, pinaka preferred. PUP graduates ang pinaka preferred ng employer. Di ba? So, ibig sabihin nun, the employer is not precluded from something went wrong. Ayan, okay. The employer is not precluded from offering a salary higher than or above minimum wage. Yung sinasabi lang natin, iyan ay minimum terms. No? Pwedeng, by all means, pwedeng mag-alok ang employer ng mas mataas na sahod. Pero doon sa mga siguro hindi kasing palad natin na inalok ng employer na mataas na sahod, dapat naman wag abusuhin at dapat ay at the very least minimum yung wage na iaalok. You understand? So yun lang ay example ng labor standards. Pero it's not always about wages. Yung labor standards, it can also set the minimum standards for hours of work. Paano naging minimum ang hours of work? Time is infinite. O, di ba? Sasabi. Hindi. Ang ibig sabihin natin na nagsiset ng standards for hours of work. Halimbawa, sa batas natin ngayon, standard ang 8 hours per day of work. Standard yan. So, kapag lumagpas, pinagtrabaho tayo sa pribadong sektor ng mahigit 8 oras, yung lagpas sa 8 oras ay supposedly babayaran ng employer ng overtime. This is something that I failed to emphasize when we started. When we speak of labor law, although it refers to manggagawa, worker, employee, you have to understand there's a different set of law governing workers in the civil service. So when we speak of labor law, it only refers to those working or employees in the private sector. Bakit ganon? Kasi nasa saligang batas, ang mga nagtatrabaho sa gobyerno ay dapat subject to its own set of civil service laws, rules, and regulations. Bakit? For example, sa civil service, bawal ang nepotism. 'Di ba? Sa civil service, meron tayong makinarya dyan para tanggalin ng empleyado. Sa civil service, meron dyan ang sinasabi na bawal ang lunch break. So meron silang pros, lahat ba sa labor law, may pros and cons. Sa civil service, meron din. Kagaya nun, so nabanggit natin ang lunch break at sinasabi natin na ang minimum terms, hindi lang limited yan sa sweldo, including hours of work. So while we mentioned earlier that in a normal day of work, it's supposed to be 8 hours as a standard. In excess of 8 hours, kailangan may overtime pay. Kung matapat pa yung 8 hours mo ng 10 p.m. up to 6 in the morning the following day, hindi lang overtime siguro, baka night shift differential pa. Napag-aaralan natin or pag-uusapan natin next week. At alam niyo ba, nabanggit yung bawal, walang lunch break sa civil service. Aba, sa pribadong sektor, kailangan magkaroon ng lunch break na at least 1 oras kapag at least or pagka 5 hours na nagtatrabaho ang empleyado. Attorney, bakit sa pinagtatrabahuhan ko or sa pinagtatrabahuhan ng kapatid ng pinsan ng kapitbahay ng bayaw namin, after 4 hours magtrabaho, lunch break na. Hindi 5 hours. Tama yun. Ang sinasabi ng batas, again, minimum terms, labor standards. Ang sinasabi ng batas, basta hindi lalagpas ng 5 oras na continuous work, dapat ang empleyado magkaroon ng 1 hour lunch break. Ngayon, kung parang naisip ng employer na, teka muna, kung 8 hours yan, after 5 hours magla-lunch, pambihira, parang hindi hati ng maayos. Diba? So pag naisip niya magpa-lunch na siya after 4 hours, okay lang. After 3 hours, okay lang din. Paano yan, attorney? Mas mahaba after yung kanyang work after lunch. Okay lang kasi hindi lalagpas yun ng 5 hours. Kasi 3 hours, break time, plus 5 more hours, 8 hours. Pag lumagpas ng total of 8 hours, overtime. Bakit may ganon? Kasi nga, yun na nga po, labor standards. So that's it. Example pa lang yan. No? We'll elaborate labor standards or work conditions later on. How about labor relations? Pag labor relations naman, ang binabalanse dyan yung institutional mechanisms at saka lahat ng mga sistema that govern individual and collective interactions between employers, employees, or their representatives. Now, ngayon, labor relations yan, maalala nyo sa PUP at sa iba pang mga state-run universities and colleges. We have what we call College of Industrial Relations, or we have come across that term, industrial relations. You might be asking, what is the difference between labor relations at saka industrial? Anong pinagkaiba ng dalawa? Actually, the two terms, labor relations on the one hand and industrial relations on the other, they're basically the same. They are practically interchangeable. However, merong mga ibang academicians na ang labor relations, ginagamit nila yan sa mga scenario involving companies where there is unionized activity. May mga union, labor relations. Okay? At ang industrial relations naman, ginagamit nila yan doon sa mga companies na walang union, non-unionized, no? O kaya naman yung labor relations ginagamit nila sa internal, sa labor sector, internal. Samantalang ang industrial relations ginagamit nila yan sa management labor interactions. Okay. Sa pananaw ng mga medyo bata-bata na mga profesor sa batas at sa labor, same banana, same pareho. You can interchange the two. So you don't have to be conscious, no? Labor relations and industrial relations, they are practically the same. They are interchangeable. So this labor standards one hand, labor relations on the other. Okay. Now, if you'd be taking up law, or some of you are already taking up law, you will see that there are 3 subjects in labor law: labor standards, labor relations, and social legislation. This might be confusing because I mentioned to you earlier, labor law, which is comprised of labor standards and labor relations, is basically a part of social legislation. But social legislation is not only limited to labor law. Social legislation also covers agrarian reform. Hindi labor yan, no? At saka social security system, social security law, GSIS law, PhilHealth law, Pag-ibig law. So hindi lahat ng labor ay social legislation. Hindi lahat ng social legislation ay labor. Nag-spill over yan sa agrarian, sa SSS. Kaya pagdating nyo sa law school or kung pinag-aaralan nyo ang law proper, ang labor standards, labor relations, tas yung kanina, social legislation. Yun. Okay? Pero ngayon, for purposes of our discussion and for the next 4 Mondays, after this Monday, we will be concentrating on these 2. Alright? Ang haba ng intro ni Attorney Chris. Ang haba ng intro. Ayun ang topic na inasign sa akin nila, ma'am. Labor standards, diba? Okay, and rights of workers. So, I know it's starting to bore you. Well, things are gonna get more interesting after this slide. So we go now to what you need to know, what the rights of workers are. No? So, ang sinasabi kasi nga dyan is, ang labor law ay nakatilt yan always in favor of the employee. Pero it doesn't mean, like the example I had in the bullfighting, hindi lahat palaging nananalo yung matador. Hindi lahat palaging talo yung bull. 'Di ba? May pagkakataon din na pinapanigan yung employer na sa labor case. Bakit? Kasi hindi rin maganda na sa ating society, hindi rin maganda na automatic kapag nagreklamo si worker, olats na si employer. Naintindihan nyo? Wala nang magtatayo ng business dito. Wala nang magtatayo. And you know what happens if we don't have businesses, we don't have employers, we don't have investors. It's gonna be difficult for us economically, no? So, ganun din at the same time kasi dahil pagdating sa resources, sa positioning, mas nakalalamang din naman ang capital. So ang ginagawa kasi natin, 'di ba? I-imagine mo ang scale. Timbangan, okay? Mas nakalalamang yung capital pagdating sa resources, pagdating sa kanyang kakayanan na ipagtanggol, itaguyod ang sarili niya, mas nakalalamang ang kapital. So, tilted heavily in favor of capital. So, what happens? We have to balance. We have to balance. Di ba? Ito mabigat eh. Ayan, kita ba sa camera? Lalayo pa ako. Ito mabigat. So, ibabalance mo yan. Paano mo ibabalance kung mabigat to? Kailangan lalagyan mo ng pabigat yan. Di ba? Anong pabigat? Bibigyan natin ng pera? Wala. Limited ang resources natin. Di natin pwedeng bigyan ng pera yan. Yun yung sinasabi na those who have less in life should have more in law. So to tilt it in favor of the worker. Now, what can tilt it in favor of the worker? Labor law. Labor law. So it's tilted. Now, that's why I mentioned, but you said, attorney, it's inclined to rule or it's inclined to be construed in favor of the laborer. So how is it gonna be balanced? Yun na nga po. Kasi ang default niyan, without a protective mechanism like labor law, ang default niyan, mas matimbang ang resources ng capital. So ang labor ang magbabalance. Hindi intensyon ng ating saligang batas, ng ating labor code, na ipinasayan para palagi na lang papanigan si worker every time, 24/7. Hindi, otherwise, we are going to lose that balance that we are trying to maintain. You understand? So for that, that's why it's tilted heavily. It's tilted. What is being tilted, take note, is labor law. It's being tilted in favor of the worker for us to have that balance we're trying to maintain. Now, nobody's perfect. Nobody's perfect. And there's always room for improvement. Sometimes that balance appears not to be maintained well. But that doesn't mean it's not necessary to have a labor law or to have a protective mechanism that could address that apparent imbalance between the two. Okay? So kaya yun, meron tayong rights of workers ngayon. Meron tayong rights of workers. Nandiyan sa Constitution yan. Kasi sinasabi ng saligang batas, yung Estado, kanyang ina-affirm na ang labor ang primary social economic force. Kahit anong dami ng pera ng uring kapital sa Estado, kahit anong daming pera din ng gobyerno, kung walang magtatrabaho, ano yan? Nangatain nila yung 1,000 nila. Diba? Kailangan talaga mayroong uring manggagawa. They are the primary social economic force. And because of that, the state has to protect the worker. How? By assuring them, giving them rights. There should be full protection to labor. But at the same time, take note, there must be also a leeway for the employer. And that's why they are given management prerogatives in certain instances. Okay. Now, what are the rights of workers? Ito muna. Kasi limang araw tayong magkikita, 5 Mondays. Okay? Dali lang. Okay. yung sa first day natin, rights of workers and management prerogatives, wag ko kayong magseselos na pinag-uusapan natin lengthily ang management prerogatives. Ngayon lang yan. Kasi dahil ngayon pa lang nagsisimula na tayo mag-usap about rights of workers, sa susunod na Lunes at yung mga susunod pang Lunes until December 9, puro workers ang bida. You understand? So mamaya, parang kang paspas ng discussion ng rights of workers. Kasi madadatnan nyo pa ulit yan. Yung management prerogatives, ngayon nyo na lang maririnig yan. Sa susunod na Mondays, hindi na. Kagaya nito, right to fair wages and protection against unlawful deduction. That's one of the rights of the workers. Now, I'm going to discuss to you their rights in no particular order. Okay? Hindi ibig sabihin na una, itong pinakamahalaga at nahuli, hindi siya importante, hindi siya mahalaga. Ngayon, kagaya nito, pag-uusapan natin ngayon yan, papasadahan natin kasi next week, pag-uusapan natin extensively yan. Okay, so intro pa lang. Intro pa lang. I'm just trying to remain true with the topic, rights of workers. Okay, so one is right to fair wages and protection against unlawful deductions. Now, what do we mean by that? Fair wages, since the state understands that if it's not setting a minimum, arriving at a fair amount of wage would probably be next to impossible. So the state sets a minimum standard, and the employer, the employee, they can negotiate to have something higher than what is minimum. Pero regardless, if they fail to negotiate or merong iba na competitive, mas mababa ang sweldo ko na willing akong tanggapin kaysa dyan sa ina-applyan ni Miss A or ni Mr. B. Ganun pa man, kailangan hindi bababa below minimum yung sahod. So that's right to fair wages. Bukod doon, bawal din basta-basta kakaltas, no? Kung kayo ay nung college may nagpapaluwagan, nabutan niyo pa ba yung paluwagan? Parang hindi niyo na alam yung ang dadaming pera ng mga estudyante ngayon, hindi na sila nagpapaluwagan. Ano nangyari sa PUP? Anyway, dito, ganun din mga empleyado, pwede kayong magpaluwagan among themselves. Pero ang employer, na siya ang nagpapasahod, hindi siya basta-basta pwedeng magkaltas sa sahod ng empleyado. Hindi pwedeng susunod siya kunwari sa minimum wage, tapos biglang babawiin niya yung pagsunod niya by imposing certain deductions that are not allowed. So what are those deductions allowed? Ito na yun. Nakikita niyo, we have taxes, withholding tax, SSS, PhilHealth, Pag-ibig contributions. Okay. Limited lang ba ang mga kinakaltas dun sa nabanggit natin? Hindi po. Pwede pang magkaroon ng ibang deductions, pero dapat ito ay may consent ng empleyado. So anong example? Kung kayo ay nagtatrabaho na sa mga ibang pribadong kumpanya, minsan maiisip nyo, ang PhilHealth benefits natin ay hindi sufficient. No? So ginagawa ng employer ng paraan na kung ang PhilHealth natin benefits, kahit updated ang contributions, hindi minsan sufficient. Kung ginagawa, ini-enroll ng employer si employee sa HMO. HMO. Okay? Ngayon, ito sasabihin ko sa inyo. Isa yan sa lamang ng mga empleyado sa pribadong sektor kesa sa government. Bakit? Sa government, madalas sa hindi, ang Commission on Audit, pinagbabawal ang agency na mag-engage, mag-member sa HMO. Ang sabi kasi ng PhilHealth, ang sabi kasi ng COA, meron na kayong GSIS, malaki deductions niyan, meron na kayong PhilHealth, hindi na nyo kailangan mag-HMO. Tapos pangalawa, ang magbabayad ng HMO, sino? Agency. So, kino-question ng COA yan. Pero sa private sector, yung other instances ng HMO, merong mga arrangement, depende sa negotiation, merong ibang mga employers, sinasagot nila 100% ng HMO. merong mga employers, and understandably, medyo hindi pa ganun kalaki, hindi pa ganun ka-stable financially, pwedeng hati sila ng employee, may share sa employer, may share sa employee. Yung share ng employee, para hindi mabigat, kakaltas sa kanya all throughout the year. So yun yung tinatawag na may express consent ng employee. Bakit? Kasi on the average, ang HMO, which is different from PhilHealth, ang HMO, mga presyo niyan, as cheaper as 10,000 per year, or it could be as expensive as 60,000 per year. So, minsan the employer in good faith, and unfortunately, meron namang employers na they want to provide maximum health benefits to their employees. Gusto nila isagad 60,000. Kung ikaw naman empleyado, ang sahod mo sa isang buwan, 50,000 for example, or even lower, mabigat ang 60K. Pero gusto mong i-avail. Pero paano kayo maghahati ngayon yan? Di ba? Kasi ano ba kalahati ng 60? Kaya ako nag-abogado dahil bobo ako sa math. Ano kalahati ng 60? 30,000. 30,000. O, huhulugan mo ngayon yan for the entire year. I-deduct sa'yo yan. Pero binayaran na ng employer mo kasi walang HMO na papayag na sinasagot niya yung health benefits mo na hindi siya fully paid. So what the employer will do is to take care of the full payment and then collect the remaining balance or the employee share via deductions every payday. So it happens because there is consent by the employee. So that's one example. Okay, I'm checking the time. So sometimes I get lost. So it's 2:41. And still, you can see, I think you can see in yours. Can you see it in your slide? Can you see it there? The number of slides remaining? Can you? You can't? Oh, too bad. I can see it from here. So still have 100 slides remaining. I'm just kidding. It's only up to 29. It's only up to 29. So this is slide number 9. Oh, we still have 20 more to go. All right. So next, the right. Ito, pinaka-common, security of tenure. So ano ba yung sinesecure? Tenure. Ano yung tenure? Yan yung karapatan ng empleyado na kapag siya ay namasukan, nagtrabaho, ang hirap naman yun na nagtatrabaho ka na hindi ka certain, putya, baka sorry, pardon my French, baka kinabukasan matanggalan na ako ng trabaho o wala na akong papasukan kinabukasan. Di ba? Ikaw pinapasweldo ka na, para ang iintindihin mo na lang is gawin mo yung trabaho mo. I think it would be too much. Kung pati ba naman, kung may trabaho ka pa kinabukasan o next week o next month, iintindihin mo pa. Ang hirap nun. Ang hirap nun. So anong sagot dyan? Meron silang karapatan to a security of tenure. Hindi sila basta-basta pwedeng alisin. Pero yun na nga, that right, there is no right actually. Let me emphasize. Walang absolute right. Lahat ng right, merong limitasyon yan. Including right to security of tenure. So, although there is this right of security of tenure, it doesn't mean that the employee could never, ever be terminated. If there is just or an authorized cause for termination and there is observance of due process, then over the right of security of tenure, the employee may and can be dismissed. And we'll be discussing that also in the subsequent lecture series that we have, or subsequent sessions, rather. Subsequent sessions. So, security of tenure. Now, attorney, ano ba yung mga, bakit yung sa ibang kumpanya, 6 months lang? Okay. Maraming klase ng employment. We'll be discussing that also. We have contractual, we have seasonal, we have project employees, but these are variations brought about by the necessities of the particular scenario. So for example, in a project employee, construction company ka, papatayo ka ng building, ikaw ang nagtatayo ng building, may kliyente ka. Hindi forever merong tinatayong building. So, ibig sabihin ba nun, pag walang project, pag walang kontrata, papasweldohin mo sila? Hindi yun. Otherwise, walang mag-i-invest sa construction. So anong nangyayari? Pinapayagan ng batas na magkaroon as an exception to this general rule of regular employment where security of tenure is given. the law allows for certain exceptions, one of which is project employment. And that is, during the duration of the project, hindi sila pwedeng sibakin, tanggalin, unless may just or authorized cause at saka may due process. So, ibig sabihin, security of tenure is still there, although for a limited time. And that is during or all throughout the duration of the project. But it's not as simple as that. Kasi in the first place, dapat kung project employment yan, sa umpisa pa lang, nakalagay sa kontrata ng empleyado na project employment yon. Hindi pwedeng nagpirmahan kayo ng kontrata, ang ganda ng sweldo, ang ganda ng benefits, tapos after 3 months, biglang sinabihan ka, ay, nakalimutan namin, project employee ka lang pala. Hindi pwede yun. Foul yun. Dapat sa simula pa lang, sinasabi na alam na ng empleyado na project employee, yung project employment, yung pinapasok niya. Para siya ay maging valid exception sa security of tenure. You follow me so far? Am I boring you already? Not quite. Let me try that again. So another slide is another right pala, another slide is right to safe and healthy work environment. Healthy work environment. Given na yan. Di ba? Ano ba yun? Kailangan ang employer nagko-comply siya sa mga health and safety standards. Health and safety standards to protect the workers from workplace hazards. So, hindi pwede yung papapasukin ka sa kumpanya na patatawirin ka sa lubid sa taas ng building para makatawid ka sa IT department. O kaya ipa-follow up mo yung lumabas na ba yung 13th month natin? Nandun sa HR. Ang dadaanan mo sa fire exit ng building na kinakalawang na yung ladder. Paano pagka medyo mabigat-bigat ka? Pag napigtas yun dahil kinakalawang na, bye-bye. Diba? So bawal yan. Or 100 ng empleyado tapos ang CR iisa lang. Tapos hindi unisex pa. Anak ng tokwang malagkit. Hindi pwede yun. Hindi pwede yun. Diba? So yung mga simpleng bagay na ganyan, we fail to realize karapatan natin. Hindi pwedeng mahiya Hindi, parang generics pharmacy. Huwag kang mahiyang magtanong. Hindi pwede. Yan lang ang CR natin. Oh. Yung tipong sa probinsya, yung yero lang na lalagyan mo lang ng tali. Pag tinadyakan yung yero, baka tanggal yung buong partition. Hindi pwede. Huwag kayong mahihiya. So, ang bawat empleyado, bawat isa sa atin, we have a right to safe and healthy work environment. Okay. Yun. Or isa pa sa mga construction, 'di ba? Minsan matataas ang kanilang pinagtatrabahuhan, mga engineers, ang mga architects. O 'di ba, yung mga electrical engineer natin diyan, 'di ba? Aakyat kayo ng minsan kailangan niyo sumampas sa mga poste ng mga telco. Paakyatin kayo, ang gamit niyo lubid. Hindi pwede, dapat harness. Hindi pwede. Mataas naman sweldo namin. Kahit na. You have the right to safe and healthy work environment. And what can you do if you have that impression, or you can see that there isn't, or the employer is being short of providing this one? What can you do? As part of that right to safe and healthy work environment, you can report unsafe conditions without fear of retaliation. If you get terminated because of that, it violates your security of tenure because it's a termination not based on just and authorized causes. You can complain for constructive dismissal or illegal dismissal, which we'll be discussing next week. Okay? Another right is self-organization and collective bargaining. Karapatan yan. Although, syempre, let's be honest about it, may mga employer, takot yan. Kasi, parang Golden State Warriors yan eh. There is strength in numbers. And you get to have a powerful, you get to have leverage to negotiate better terms and conditions. Why can you negotiate? Are you allowed? Yes, kasi minimum nga yung sineset eh. Hindi precluded ang mga empleyado at ang mga employer na magkaroon ng mas mataas na benefits higher than what is minimum, set as minimum. So for that to happen, sometimes it's difficult for the employee to negotiate on his own or on her own. So they are allowed to organize among themselves. They are allowed to form unions. And being a union, they can collectively, take note, collective. Bakit? It's called collective because marami sila. It's also called collective because the benefits that they will be enjoying will be enjoyed by the rest of the employees. Collective bargaining. Hindi pwedeng si Group A, mahirap mag-drawing, huwag na. Si Group A ay mahilig mag-Starbucks, sila lang ang mayroong dispenser na Starbucks coffee. Samantalang si Group B na hindi mahilig mag-Starbucks, blend 45 yung nasa dispenser nila o 3-in-1. Hindi pwedeng ganon. Collective yan. Collective, kaya nga collective bargaining. Yun yung tinatawag doon. But when we say collective bargaining also, it does not preclude the parties from having certain terms and conditions that are quite different from the other kinds, other classifications. So for example, meron tayong tinatawag na field personnel or tinatawag na supervisory, meron tayong tinatawag na rank and file. Merong mga ibang benefits accorded sa rank and file na wala sa supervisors or sa managers and vice versa. But still, it does not lose its characteristic of it being a collective bargaining. Okay, halimbawa sa mga airlines, 'di ba? Pwedeng magkaroon ng collective bargaining ang mga piloto. Yung mga benefits sa piloto dahil sila nagpapalipad ng eroplano, it doesn't have to be enjoyed. It did not be enjoyed by flight stewardess or yung mga ground crew. Iba kasi ang sitwasyon. Pero lahat sila, pwede silang mag-bargain collectively. Pero they may have different benefits afterwards. Okay? It still does not lose its characteristic as a collective bargaining agreement, CBA. Okay. Now, this CBA, it will not be possible if the employee is not given the right to self-organize. Wala kwenta ang CBA na yan kung walang right to self-organize. Okay. Ano pa? Ang karapatan ninyo. Right to equal work opportunities. Ano yan? Bawal ang diskriminasyon. No? So, hindi porke halimbawa ang trabaho natin ay accounting. Di ba? Hindi pwede na i-hire mo accountant puro gwapo't magaganda. Dapat mag-hire din ng pangit. 'Di ba? Walang kinalaman ng itsura sa pagbalanse ng sheets. Kahit pangit kaya magbalanse niyan. 'Di ba? Walang kinalaman ng looks. Bawal mag-discriminate. 'Di ba? Buti na lang magaganda yung mga nasa PUP. Kaya bawal, hindi pwedeng kayo lang palagi na-hire. Dapat mga pangit din. Okay? Kasi nga, right to equal work opportunities. Okay? Pero minsan, alright, eto. Meron tayong tinatawag na bona fide, bona fide, in good faith, occupational qualifications, BFOQ. Diba? BFOQ. Well, by letter na lang, wag na nating paigsi na BFOQ. Diba? BFOQ na lang. Pangit baka ibang dating BFOQ. Ano yung mga yon? In good faith, may mga occupational qualifications na kailangan talaga tumingin tayo sa gender, sa edad, or even sa religion. Okay? Or sometimes even based sa political beliefs. Bakit? For example, pagdating sa edad, syempre yung mga trabaho na physically taxing, yung mga magbubuhat ng mabibigat. Mahirap naman kung ang ire-require mo na empleyado mag-a-apply, ang empleyadong tatanggapin mo, na bawal kang tumanggi. Na bawal tumanggi kung ang nag-a-apply ay mga edad 90 pataas na. Baka mamaya alam mo na, di ba? Mahirap 'yon. So okay lang na magkaroon ng certain bona fide occupational qualifications. And we'll be also discussing that in detail next week, next time. So, pero ang general rule, pag wala namang kinalaman ang itsura, ang edad, ang kasarian, di ba? Ang reliyon o political beliefs, pag walang kinalaman sa trabaho, bawal mag-discriminate. So karapatan natin yan. It's a right to equal work opportunities. Okay? Another right. Yan. Itong pinaka-paboritong, next to minimum wage, itong pinaka-paboritong right ninyo, I would suppose. Right to rest and leisure. So, nabanggit natin, it's still part of labor standards, working conditions. Why? Because, for example, after 6 days of work, at the most, you're entitled to 1 rest day. Bakit, attorney, sa amin, after 5 days, 2 rest day? O, swerte mo. Tara, magreklamo tayo. Siyempre, di ka magre-reklamo. Yun ay sinasabi nga natin, maximum of 6 days, kailangan 1 rest day. Yun ang maximum. Pero karamihan, kagaya sa aming law firm, maximum work, days of work, 5 days, 2 days na rest day. No? We could shift, we'll be discussing management prerogatives. Any employer can shift from 5 days work week to 6 days, dependent, but it's not as simple as that. There has to be an employee concept. But the point being, when we speak of right to rest and leisure, maximum of 6 days of work, there should be at least 1 rest day. It could be 3, it could be 2, doesn't matter. The point is, minimum is 1 rest day after 6 days of work. No? So, di ba, meron yung nagkakabukingan minsan sa social media, Boss, di ako pwede mag-OT kasi may lakad kami may emergency ako, tapos biglang mapopost, nasa beach, ganito itsura, yan, no? Nandyan yung paa, nandyan sa paa. At the moment, ATM, di ba? Naka-check-in pa kung anong beach, patay, huling-huli ng boss. Can that be taken against you? Well, it's not simple to answer that because first and foremost, you have 1 rest day after 6 days of work. But in certain instances, the employer, certain grounds we'll be discussing next week, the employer can sometimes demand overtime, or the employer can sometimes demand the employee to render work at his or her rest day. But if that happens, if it falls under the exceptions, the employer is still required to pay the employee overtime, night shift differential, or premium pay as the case may be. Okay? But if it does not fall under the exception, naglalambing lang yung employer kasi tatakot siya magtrabaho ng mag-isa sa weekend dahil daw minumulto yung office nila. Papupuntahin ka, hindi naman urgent. At tumanggi ka. Sinabi mo emergency, pero nakita ka niya, hindi huwag ka mag-alala, hindi ka pwedeng sibakin dahil doon. No? Pero ganun pa man, para maiwasan yung awkward scenario, huwag ka magpo-post sa social media. Wag. Awkward day. Awkward. Hindi ka pwedeng sibakin. Hindi ka pwedeng sibakin. Dahil dyan, pag nabuking ka, magdadala ka patali ng pasalubong sa boss mo. Di ba? Para suyuin. O, wag na. Wag na. Ano mo na lang, store mo na lang muna, saka mo lang i-post kung kailan nakalimutan ng lahat na nawala ka nung araw na yun. Gawain nyo, no? Gawain nyo. Ang tawa ninyo, malupit, halatang gawain. Okay. Also, under this right to rest and leisure, they also have the right to paid leaves. So, alam nyo ba na hindi kagaya na sa PUP na kapag absent ka, ililista ng professor yan pag wala ka for recitation, absent ka, yari ka na, di ba? O quiz. Hindi ka na pwedeng bigyan ng special exam. May direct message ako. Wala. Okay. Sa atin, pwede ka pa rin magkaroon ng rest and leisure at sumusweldo ka at the same time. O, di ba? Pag-uusapan natin yan. Ano yun? Kailan yun? Meron tayong tinatawag na service incentive leave, no? For those who have worked already for at least a year. Meron tayong maternity, paternity, solo parent leave. Meron tayong sick leave, so on and so forth. So, malawak yung right to rest and leisure. Malawak yan. Merong mga instances na bayad, pero as I tried to impress upon you earlier, hindi lahat ng rights ay absolute. May limitasyon. Alright? Ano pa? Nabanggit natin yung service incentive leaves, maternity, paternity. Ano ipambabayad sa iyo ng employer mo kung ikaw nag-maternity leave? Kasi with pay yan eh. Alam nyo ba? With pay yan. Ilang buwan kang naka-maternity leave at sumesweldo ka. Saan kukuha ng pambayad sa iyo yan? Siyempre, kung mabait yung employer mo, maraming pera, siya ang sasagot, napakasarap, salamat naman. Pero doon sa mga pagkakataon na walang pera si employer pang abono sa ganyan, dapat sagot siya ng SSS ng PhilHealth. Kaya tayo merong right to social benefits. Galing, no? Transition tayo sa next slide. Social benefits. So, this right of an employee is translated into an employer's obligation to make sure that it pays to the SSS, the PhilHealth, the Pag-ibig, the necessary contribution. Remit ang tawag to. Remit. You remember kanina we have the right to fair wage at saka right against unlawful deductions. Now, because of this right to social benefits, it gives way to the scenario where the employer is allowed to make certain deductions as part of your employee contribution. So, hindi lahat ho ng social welfare benefits gaya ng ito, si employer ang sumasagot. Merong employer share, merong employee share. Merong pagkakataon, again, kasi minimum standards ho yan, ha? May pagkakataon ho na mabait si employer, sinasagot niya ang employee share. Thank you naman pag sinagot niya. Pero doon sa hindi ganun kapalad, at the very least, the employer has a specific share in remitting contributions for these social security benefits. Nang sa ganon, kapag kayo ay nag-maternity or paternity leave, for example, meron kayong panggastos, pambayad sa ospital, pambayad sa gatas ni baby, and so on and so forth. So, social benefits. It's a right. It's a right of the employee on the one hand, and it's an obligation of the employer on the other. Okay. Now, yun yung sinasabi na dahil nga kunwari bakasyon ka ng within your rest day na hindi nagpapaalam, pwede ka bang sibakin ng employer mo? Hindi pwede. Bakit? Meron kang right to due process in disciplinary actions. This is an adjunct of the security of tenure we mentioned earlier. No? Ang problema lang kasi, kaya natin hiniwalayan, hindi lahat kasi ng disciplinary action nangangahulugan, tsugi, sibak, sisante. Hindi lahat. Bakit? May mga disciplinary actions that result to termination one. It could also result to suspension or to demotion or reprimand. So, when we speak of due process in disciplinary actions, it's not limited to termination proceedings. So, kailangan yan may due process. Now, pag sinabi kasi nating due process, kaya nung ako ay hindi pa ako nag-aaral ng abogasya, parang ang due process, saan lupalop nakuha yung term na due process? Pag sinabi mo kasing process, proseso, procedure. Di ba? Pag sinabi mong Jew, yan yung soft drinks na green na lemon flavor. Hindi. Hindi yon. Pag sinabi mong Jew, yung kinakailangan. Yung kinakailangan na proseso. Due process. Yung kinakailangan na proseso. May karapatan kayo doon sa kinakailangan na proseso bago kayo disiplinahin. Ano yung kinakailangan na proseso na yan? To notice. Pangit ang number 2 ko. Basta yan. To notice rule. Una, merong notice sa empleyado na ini-inform siya, meron siyang atraso. At kailangan naka-specify. Hindi naman sobrang detalyado. Hindi naman kinakailangan na complete inventory of whatever she did or he did. But it's enough for the employee to be apprised what is being imputed against him or her, and for the employee to intelligently prepare her defense. So that's the first notice. That's one. Notice to be informed of the charge. And then there's another notice later on. And itong plus na to, during that period, the employee should be given the opportunity to defend himself or herself. That's part of the process. That's part of the due process. Okay? So, hindi pwedeng pag nag-decide na bad trip sa'yo si boss, wala nang due process, wala na to. Si baka na kaagad magde-decide. Hindi pwede, kailangan meron munang due process bago maabot yung desisyon nila na second notice. Ano yung sa second notice? Kailangan kung ano man desisyon ng employer, inform din niya si employee. Ilalagay niya doon yung desisyon, hindi lang yung literal na desisyon na hindi kita bet, tsugi ka, or suspendido ka, or demoted ka. Bakit? Basta. Hindi pwedeng ganon. Ang second notice requirement dito, kailangan ini-inform sa employee saan ako nagkamali. Saan ako nagkamali. Yon, dapat ini-inform siya. 'Di ba? By the way, yung due process requirement na yung 2 notices, 'di ba? Yung during the time na nag-explain sa employee, kung kaya niya or may kaibigan siya, kagaya ni Attorney Chris Garganchiel, pwede siya ipagtanggol ng abogado. It's a right to counsel. So, we have 200, labo ng mata ko, man. We have approximately 300 participants. Iba pa yung nasa Facebook. Pag kailangan nyo ng assistance, bahala sa buhay nyo. Joke lang. You could reach me through the PUP Alumni Relations and Career Development Office. And we'll see what we can do. Right? Yan. So, nandun si Ma'am Florida, nandun si Ma'am Pulma, nandun si Jope. They can give you my number. If you need advice about this one, disiplina kayo, or gusto nyo lang talaga na may ililibre kayo by the time na may enjoy nyo itong nawala. By the time mag-i-enjoy kayo ng right to rest and leisure, gusto nyo manlibre, pwede rin. Pwede rin. But if you need lawyers or something like you have a problem with this disciplinary action, you need advice, I'd be glad to help. No worries. Okay. So that's what we mean by due process. Now, yung sinabi ko nga rin, di ba? Bakit kanina binanggit ko, pag sa labor law, dahil nga mabigat para ma-tilt in favor of the employee, but the tilting is done to preserve the balance. How is that done? Because of the rights I mentioned to you earlier. Now, in case of doubt, in the construction, pag sinabi mo construction, hindi yung literal na nagpapatayo ng building o ng bahay. Construction is a legal term for in understanding, digesting, construe, interpreting. So, in the process of construing or interpreting some difficult or doubtful provisions of labor law, meron kayong right to construction in favor of labor. Hindi ho kayo ipagpapatayo ng bahay. Hindi ho yan construction na libre. Ibang construction yung iniisip nyo. Yung sinasabing construction dito, yan ho ay yung pag-interpret, pag-construe. The construction is, it has two possible root words. One is construct. Yan yung pagtayo. But the one that I'm referring to is construe, pag-interpret. So yung pag-construe or pag-construct in favor of the laborer palagi. So yan yung sinasabi. Kaya nga lahat ng duda, lahat ng doubts in the implementation, in the interpretation, labor code lang ba? Hindi. Pati yung implementing rules and regulations. Lahat yan, it's resolved in favor of labor. Diba? Yun yung, ito ang pinaka common manifestation, demonstrative of the law being tilted in favor of labor. Yan ang pangunahing halimbawa ng tilting in favor of labor. Construction in its favor. Okay? Yun na lang ba ang right ninyo? Mukhang ito na yata yung huling right namin. Wala na kaming right dahil parang construction na. Meron pa, huwag kang mag-alala. You still have protection against discrimination and harassment. Oh. So the right against discrimination and harassment is also, as a consequence, the employer's obligation to observe. So bawal ang discrimination. Kanina, employment opportunities yon, no? Pero dito, pinag-uusapan natin, discrimination, pag nandun na kayo, natanggap na kayo. Natanggap na kayo sa loob. So, bawal mag-discriminate. No? Dapat humane treatment. Hindi lang sa pagtanggap, pati sa pasweldo. Di ba? Kaya nga collective bargaining, hindi pwedeng yung mahilig lang mag-Starbucks ang bibigyan ng free Starbucks. Kailangan din yung mga nagbe-blend 45. Inabutan nyo pa ba ang blend 45? May blend 45 pa ba? Meron pa. Oh, di ba? Kasi ako, wala 3-in-1 lang ako. Wala akong selan sa kape, actually. Wala. 3-in-1 lang to. 3-in-1 lang to. Malamig na nga. Ngayon, so compensation, promotion, termination. Now, pasok din ho dito, mga mahal kong taga-subaybay, mga estudyante, mga group ng PUP, ang protection laban sa sexual harassment in the workplace. Now, this one, it's not under the labor code, but it does not mean it's not an employee's right. So you will find a separate law which protects employees from sexual harassment. We have the anti-sexual harassment law. That's one. Matagal na yan. Yung anti-sexual harassment law, naglo-law school pa lang ako noong 99. So, tagal na, no? Hindi pa kayo pinapanganak nun. 1999. Naglo-law school ako 1990. Actually, nung nag-college ako 1995. Andun na yan. Tapos ngayon, during the pandemic, may nadagdag pa. Safe Spaces Act. You've heard of that? So, it protects the employee, anyone for that matter, from gender-based sexual harassment, Safe Spaces Act. And then sexual harassment, it protects the employee from, the name speaks for itself, sexual harassment. So although it's not found in the labor code, it doesn't mean that it's not an available right in favor of the employee. It still is. You can invoke it. You're entitled to its protection. It's your right nonetheless. Okay. So we have those rights, and it was quite brief. The discussion there is brief. It took me about like a little over an hour talking about those rights. But what I mentioned to you guys earlier is that ito yung parang overview. In detail, i-discuss natin yan in the following days, the following sessions. Now we go now to, well, yun na nga eh. If they have rights on the one hand, if the employee is like you, sir, libre po ba? Eh, pwede naman. Oh, pumirenda na lang, kahit halo-halo na lang dyan sa may Teresa. Libre. Good afternoon. Is it within an employee's right to decline answering company calls received after work for non-working days? Well, yeah, it is. It is. It is. But you also have to, kasi minsan talaga emergency, you also have to be considerate, no? Anyway, can I go back to those questions? Bawal bastos. Yeah, that's correct. I'll go back. We'll have, I think, sufficient time for the Q&A. I'll get back. Tapusin lang natin to. So, di nyo nakikita ang listahan ng slides. Nasa number 17 na tayo out of 29. So we're more than halfway. Tama. More than halfway. So we move on. Management prerogative. So kailangan balance. Hindi yung pwedeng palaging yung bulang nananalo. Diba? I mean, soup number 5, minsan maliit yung sahog kasi hindi lahat palaging toro yung nananalo. Natatalo. Diba? Hindi palaging ganun. So ano yung mga yan? Management prerogatives. Kahit ang saligang batas natin, hindi niya constitution, hindi niya na-overlook yung karapatan ng kapital. Kasi ano yan the state is recognizing the importance of the private sector. Ini-encourage niya ang private sector, ang private enterprise na mag-invest, mag-operate ng business kasi kailangan yan sa economy, no? Ganun din dahil doon, mamandate yung Estado to regulate yung relations between workers. Kaya nga, yung madadatnan natin next week, sino ba ang dahil nabanggit natin, ang batas ang nagsasabi na magseset ng minimum wage for every region in the country. No? Ang tawag doon sa body na nagseset ng minimum wage rate, tripartite. Ano ibig sabihin ng tripartite? 3 parties, no? Merong pre-party, party proper, after party. Yun ba yung tripartite? Hindi. 3 partido. Party representing the employee, a party representing the employer, and the government. Tripartite. Bakit? Kasi mandated ang Estado na i-regulate yung relationship between workers and employers. Pag hindi na magitan ng Estado, magbababag yan. Magsasabunutan, magsasampalan yung mga yan. Kailangan taga-awat siya, taga-balanse. Taga-balanse siya. And then the state also recognizes that even if labor is entitled sa fruits of the production, entitled siya dun. How? Bonuses, 13th month, fair wages. Yung enterprise, yung business, it also has an equal important right sa reasonable returns on investments na you've heard ROI. Ano yung ibig sabihin ng ROI? Uy, galing, ROI ka na. ROI ka na. Ano yung ROI? Para siyang ano yung Attack on Titan? AOT, no? ROI, returns on investment. But the returns on investment, hindi pwedeng ano yan. Walang limit. Reasonable lang. Huwag masyadong greedy. Reasonable returns on investment. Bakit? Pag hindi reasonable, wala nang share si labor sa fruits of production. Remember, kailangan i-balance. So because the state recognizes the right of the enterprise to a reasonable return on investment, the state accords the employer, it's not rights, but rather management prerogatives. Management prerogatives. So, nag-drawing ako dito. Iniintay ko sa Facebook Live. Ngayon pa lang pumasok sa Facebook Live. So, medyo delayed siya ng mga 5 seconds. Okay. So, ano yung mga management prerogatives na meron tayo? So, we're now on slide number 18. We still have 11 more slides to go. Now, so, ayaw mag-switch yan. First, management prerogative. Ito naman yung may employee rights on the one hand, may management prerogatives naman on the other. Ano to? Meron siyang prerogative to merong naiwan na annotate, no? May linyang green. Nakikita niya ba? Ito. Nakita niyo yung linya na green?
Opo, meron.
May nag-annotate, no? Okay lang, okay lang. Paano ba tanggalin yun? Okay lang ba kayo? Hindi niya kayo nadidistract? Yung may mga obsessive compulsive disorder kasi dito, kagaya ko.
Okay
Parang,
lang, sir.
di ba? Yung parang, ayan, okay lang. Okay lang yan. Sige, okay lang. Deadman na lang tayo, tapos hindi ako mapalagay, no? Hindi ako mapalagay. OCD, obsessive compulsive disorder. May psychology ba tayo rito? Meron? Wala.
Meron, sir.
Oh, OCD yan, ano, yung di ka mapalagay dun sa green. Medyo. Okay lang, carry yan. So, selection of employees based on bona fide occupational qualifications. Ito yung sinasabi ko sa inyo kanina, na kahit na merong right to equal work opportunity, kailangan may BFOQs. B, F, O, and then Q. Kailangan may bona fide occupational qualifications. Para mabalanse yung kailangan ng negosyo na mag-hire ng qualified individuals while protecting employees and applicants from discrimination. So binabalance yan. Yung karapatan ng negosyo na mag-hire ng qualified at the same time, pinaprotektahan yung karapatan ng empleyado against discrimination. Okay. Isang example ng BFOQ ay Anti-Age Discrimination in Employment Act. So bawal mag-discriminate sa pagtatrabaho based on age as a general rule, no? Kasi 'di ba, example ko kanina, kung 80 or 90 years old or even sabihin natin mga iba ang lakas physically ng mga 20, 30. Di ba? Iba. Okay. So, dahil merong management prerogative nito, na ganito, they should be necessary for the job's nature and not to exclude individuals unfairly. No? So, for example, ang gender, ang kasarian, pwede siyang maging, may typo ako. Sorry, ngayon ko lang nakita. Ang gender, isa siyang bona fide qualification or occupational qualification kung ang gender ay specific. For example, ang job legitimately requires a female counselor or a female social worker for a woman's shelter. Okay? O kaya, lady guard. Lady guard ang mag-i-inspect, magkakapkap. Ano naman lalaki ang maggawa nun, de puch. Inupakan nyo na yun, di ba? Inaway kayo ng boyfriend ninyo kapag kinapkapan ako ng guard. Honey, wala akong magawa. Di ba? Hindi pwede yun. So those are examples. It must be a legitimate requirement. Gender may be a bona fide occupational qualification, but it must be important. The job legitimately requires that particular gender. Okay. So it must be essential to the role. Ano pa ba? Age-related qualifications. So isa rin yung BFOQ, ang edad. Bakit? Pwedeng ilimit ng employer na pag physical yung tasks, ililimit niya yung age up to a certain age, probably 35 or 30, di ba? Kaming mga lagpas na sa kalendaryo, nga, o minsan lagpas pa sa bingo, ang bingo hanggang 75 lang. Alam niyo ba yun? Ang bingo, hanggang 75 lang. So lagpas ka na sa kalendaryo, huwag kang mawala ng pag-asa. Bingo ka pa rin, nasa bingo ka pa. Yeah. Pag lagpas na ng bingo, pahinga na. So example, age-related qualification yon. Ang normal kasi, it cannot be a factor in hiring. Pero may mga instances na legitimate BFOQ ang age. So example nga nun, strenuous physical work. It may require younger applicants. Okay? Yung mga lagpas na tayo sa calendar, wag tayong sasama loob. Age-related qualification po yan. O, halimbawa sa sports, di ba? Ang aga ng retirement. Nagre-retire mid-30s, di ba? Bihira lang umaabot ng 40 years old. Kasi nga physical requirement yan pagiging atleta. Or pwede rin na ito sinasabi dito, bawal mag-discriminate based on religion. Pero ang religion, it can also be a BFOQ doon sa mga sitwasyon na ang specific religious background ay kailangan talaga para sa trabaho. Ano ibig sabihin niya? Pag-eskwelahan niya ng mga ministro, mga leaders, mga teachers ng religious study, hindi pwedeng ibang sect ang magtuturo. It goes without saying. Di ba? Hindi pwedeng ibang sekta or ibang denomination. Religious requirements or religion can be a BFOQ in certain instances. So, ano pa? Physical health standards sa edad. Appearance yon. Yung sabi ko kanina. Pagpangit ba? BFOQ ba ang itsura? BFOQ. No? Generally, ang appearance, buti na lang puro magaganda kayo at mga gwapo. Generally, yung mga appearance, yung mga malas-malas na hindi natin kasama ngayon. No? Yung iba kasama natin via Facebook Live, 105, huwag po kayo magtatampo. Kasama rin po kayo. Hindi talaga siya BFOQ. So parang kahit pangit, tatanggapin. 'Di ba? Pero in certain requirements, certain instances, appearance can also qualify as a bona fide occupational qualification. Bakit? Minsan may mga roles na kailangan ng specific look for authenticity. 'Di ba? Halimbawa, Department of Tourism. Magano ka, welcome to the island of whatever. Ang ipapakita mo, foreigner, may foreign features na hindi talaga authentic or hindi siya indigenous doon sa island na yon. Iba yon. Or in the case of modeling or acting, di ba? Halimbawa ay sino ba? Ang naisip ko, gender Halimbawa, sa role ko rin ni Gabriela Silang, mag-hire ka ng lalaki. Hindi pwede. Di ba? Mag-hire ka ng lalaki, ang role, Gabriela Silang, vice versa. Role na Jose Rizal, mag-hire ka ng babae. Hindi pwede. Or, appearance. Halimbawa, yung role, napanood nyo ba yung Tropic Thunder? Si Ben Stiller, saka si Robert Downey Jr., Vietnam War. Tapos yung isang soldier na pineplay ni Robert Downey Jr. Is supposedly a black soldier. But it's being played by Robert Downey Jr. Kinulayan nila ng itim si Robert Downey Jr. He was criticized for that. So these are examples na certain roles in modeling or acting require a specific look for authenticity. So yun. Minsan ang appearance, swerte na lang ninyo, hindi kayo excluded. Pasok pa rin kayo kahit na appearance is a requirement. No? Pero normally, sa mga ordinary na trabaho like accountancy, engineering, kahit mga pangit na kagaya namin, hindi pwedeng kayo lang. Kami rin dapat tinatanggap sa trabaho. Okay? So ano ang review natin? For bona fide occupational qualifications to be valid exercise of management prerogative. Number 1, it must be directly related to the job duties. Yan yung moral of the story. Dun sa mga sinabi ko kanina sa inyo. Number 2, it serves a legitimate business purpose. And number 3, pinakamahalaga sa lahat, bona fide. It must be applied in good faith. Okay, we still have one more hour to go, so I'll try to finish this. Next is productivity standards. That's another management prerogative. Hindi pwedeng pumapasok ka araw-araw, nagre-report ka for duty, wala kang output. Kailangan may output ka naman. Di ba? Hindi pwedeng pinaiinit mo lang yung upuan mo. So, si employer naman, dahil meron siyang management prerogative to impose productivity standards, huwag niyong masasamain. It's not a violation of your right if your employer once in a while reminds you to perform to perform. So the employers are required or they are given the prerogative to set performance metrics. Pwede kasing sa umpisa pa lang, pinag-uusapan nyo na yan na merong output or merong work quality, merong oras, at saka merong accuracy na expected from you. Na kapag hindi nyo nasunod, may kakaproblema tayo. Kapag nasubject kayo sa disciplinary measures dahil hindi nyo nami-meet yung mga performance metrics, not necessarily a violation of it, right? Pero kailangan pa rin i-observe ang due process, babalansin. But then again, it's still the right of the employer to enforce or to request or to enforce observance of certain productivity standards. No? Pasok din dito, pwede silang mag-evaluate, minomonitor. Kaya nga meron dyan, monthly appraisal, quarterly review, meron kayong mga key performance indicators, KPI, ano pa ba? Key result areas, KRA. Yeah. Dahil doon, pwede rin naman na re-rewardan kayo. Productivity linked incentive naman ang tawag doon. Diba, sinasabi kanina, Attorney, akala ko ba collective bargaining, collective yan, may enjoy ng lahat. Oo, pero dahil meron silang management prerogative to observe or to maintain productivity standards, binibigyan sila ng elbow room na magbigay ng productivity linked incentives or bonuses minsan. Minsan, one employee may be more productive than the other. Kaya minsan meron tayong employee of the month. 'Di ba? May mga ganyan, binibigyan niya. As an example, para pamarisan ng iba niyang katrabaho. Masama ba 'yon? Hindi. Why? Management prerogative. Productivity standards. So, kaganoon din pagka non-compliance, pwedeng maging subject to disciplinary action. Disciplinary action. Another, changing the working hours. That's a management prerogative. Pero may mga limit yan. Hindi basta-basta kung kailan na lang pagising kinabukasan ng employer. Hindi pwede. Gawin ko kayang 12 to 8 p.m. 12 noon to 8 p.m. ang pasok. Diba? Parang from 8 a.m. to 5 p.m. biglang 12. Hindi pwedeng ganon. May mga bagay na pwedeng i-adjust ng employer pagdating sa working hours. Pero hindi pwedeng padaskol-daskol. Meron tayong tinatawag na permanent change. So, pag sinabi nating permanent, medyo matagal i-observe yan. Matagal lang i-observe yung change in the working hours. So, pwedeng for example, 9 a.m. to 5 p.m. ang schedule. Pwedeng gawing mas maaga, 8 a.m. to 4 p.m. That's a permanent change. Or pwede naman temporary. Meron kasing mga deadlines or kailangan bawasan ng oras or kailangan operational slowdowns. Temporary lang naman yun. Limited duration. Ang pinaka-common na nagkakaroon ng change of working hours ay yung mga nagtatrabaho sa business process outsourcing. Bakit? Usually, ang BPO, meron silang campaign, meron silang kliyente abroad. So, iba-iba ang schedule, iba-iba ang oras. Now, if you get yourself employed by a BPO, knowing fully well that what you're getting yourself into, you have to expect that the BPO, the company you applied in, may be implementing shift changes. And these are common in BPOs. Now, is employee consent always required? Kailangan bang pumayag si employee? Kailangan ba may consent? Consent ha? Consent. Ang consent ay usually kinakailangan kung ang pagbabago, it significantly impacts the working conditions. So for example, substantial yung increase or decrease of their hours. It's so substantial na nalalamangan na sila sa night shift differential or overtime pay, or sobrang laki ng bawas, halos wala na silang sweldohin. No? O kaya sobrang dramatic yung change. 8 a.m. to 5 p.m. ang trabaho mo naman ay office work lamang, hindi ka sa BPO. Tapos biglang sasabihan ka the following week, ang gagawin natin 8 p.m. to 5 a.m. tayo. Wah! Hindi, okay lang yun. May night shift differential. Kahit na. So yung mga bagay na ganyan, pag changes sa regular working hours, changes in regular working hours plus regular R, kailangan merong employee consent. Okay, that's one. Paano pa nakukuha employee consent? Minsan pag kayo nagpirma, kagaya sa mga BPO, nakalagay na doon sa employment contract nyo yung flexibility clauses. Yun yung mga stipulations na matatagpuan nyo sa kontrata na binibigyan yung employee at saka management elbow room to make adjustments in the schedule without additional consent. Kumbaga, sinasabi na ng BPO company, Miss A, Mr. B, ito yung campaign na papasukan mo ngayon. Gusto ka namin magtagal sa amin, pero yung campaign, maaring ibang campaignan after a few months. So, ilagay na natin dito, naintindihan mo na magkakaroon ng adjustments malamang pag nagbago na yung campaign. So, these are employment contracts with flexibility clauses, and that's valid. That's valid. Now, isa pa ay employee consent sa regular working hours, flexibility clause, collective bargaining agreement. Now, employee consent, whether it's given, whether it's necessary, or even if it's not necessary, there should always be a default requirement ng notice. Iba yung notice, iba yung consent. Kung consent, whether kailangan ng consent or hindi kailangan ng consent, hindi dapat nawawala ang notice. Okay. Ang notice, binibigay yan before. No? Hindi pwede yung lalabas kayo ng mga sis mo, mga tropa mo ng weekend. Tapos sasabihin mo sa girlfriend mo, boyfriend mo after. Hindi notice yun. Hindi notice yun. Ang notice binibigay before. Di ba? Okay. Example ng consent. Nagbigay ka ng notice before. Sabi mo, Han, pwede ba akong lumabas kasama yung mga kaibigan ko? Ang sagot niya, sige, period. Tas, okay ka lang ba? Okay, period. Ba't ganyan sagot mo? Wala, period. Pag ganyan, walang consent yon. Alam nyo na yan eh. Di ba? Alam nyo yung iba, pinagkaiba na, natatawa kayo, gawain nyo rin ano. Iba ang notice, iba ang consent. So, ang sinasabi ko sa change of working hours, whether the consent is required or not, hindi dapat mawawala si notice. So kahit magagalit yung boyfriend o girlfriend mo afterwards, at least nagpadala ka ng notice before. Okay? Okay. Yun, malinaw. Transfer of employees, another management prerogative yan. Basta kalokohan talaga, gising na gising ng mga dugo ninyo. No? Transfer of employees. Isa pang management prerogative yan. Kasi this happens dun sa mga employment na maraming branches, no? Maraming branches. So mga bangko, may mga regional office, di ba? May mga malalaking kumpanya, daming branches. Even PUP, maraming branches si PUP. Pero take note again, pinag-uusapan natin labor code. So ang iba ang rule kay PUP. Kasi si PUP govern ng civil service law yan. Now, ganun din sa transfer, parang change of working hours yan. Same principle. Kailangan it should be exercised in good faith, no? May notice. At ito ang mahalaga. Ito. Good faith, it should not result in demotion. Hindi bababa yung rango mo pag na-transfer. Hindi babawasan ng benefits ang sahod. At saka hindi undue hardship ang idudulot sa empleyado. Kasi merong iba, itatapon ka sa malayong lugar dahil hindi ka bet ng boss mo. Maaring walang demotion, maaring walang bayad sa sahod. Pero undue hardship, hindi naman kinakailangan ilipat doon. Meron naman pwedeng makuha ang kumpanya na taga roon. No? Pero ikaw pang napiling ilipat doon. bawal yun. Undue hardship yan. Constructive dismissal yan. Pag-usapan natin in detail. So, kailangan talaga ay in good faith, walang demotion, walang diminution, at walang undue hardship. Now, saan madalas nangyayari yan? Business restructuring, operational efficiency, o kaya ay may mga workforce shortages. So, kulang tayo ng tao dito sa area na to, branch na to, pwede bang lipat ka muna? No? Hindi ka naman babawasan ng temporary lang yan. Ngayon, pagdating sa transfer, hindi naman porke sinabing transfer, temporary din lahat. Minsan merong mga permanent na transfers. Merong permanent transfers. This one, long-term reassignment. Hindi ibig sabihin pag sinabing permanent, doon ka na. Hindi ka na pwedeng umuwi sa inyo ng Manila pag Semana Santa o Undas. O hindi ka na pwedeng bumalik sa boyfriend mo, sa piling ng boyfriend mo o girlfriend mo kapag ka namimiss mo na siya, babalik ka ng Manila. Long-term assignment lang pag sinabi nating permanent. Pero indefinite. Hindi natin alam kung kailan ka babalik ngayon. O meron din tayong tinatawag na temporary transfer. Yun yung sinasabi ko kanina, temporary lang siya dahil kailangan lang i-cover yung mga shortages sa workforce, temporary lang yan. No? O kaya lateral transfer. Lateral transfer, same building, same branch, same office, na transfer ka lang sa ibang department. But ganun din, it should be exercised in good faith, no demotion, no diminution of pay, no undue hardship. Now, gaya ng change of working hours, yung employee consent sa mga transfers, hindi kinakailangan. Hindi lahat ng transfers, rather. Not all transfers require employee consent. It's only required if the transfer involves significant changes to the employment terms. Significant. Okay? Significant. At ganun din, okay, whether consent was made through CBA or flexibility clauses, or the employee validly gave the consent, if the consent is there, if the consent is required, or the consent may not be required by the law, notice should always be a condition. Whether consent is required or not, there should always be notice. How long should the notice be? Sasabihin, oh, lipat ka na. Saan? Dito sa isla ng whatever island. Kailan? Bukas. Wala, bawal yon. Hindi, may notice naman. Sabi ni attorney, kahit walang consent mo, basta may notice. Hindi rin. Ang notice, ideally, at least 30 days. 1 month notice. 1 month notice, depending on the situation, but normally it's 1 month notice. Okay. Discipline. Ito pag-usapan natin yan. Management prerogative. Hindi basta-basta magtanggal, pero may karapatan ang management magtanggal. No? Hindi kasi pwedeng, although may security of tenure ang empleyado, sitting pretty ka na dyan. So halimbawa, you fail to observe yung productivity standards that we mentioned earlier. Siyempre, ang employer, di ba, sungit ng employer dito. Nakabaw siya, parang bait. Siyempre, ang employer, meron siyang prerogative to require productivity standards, to observe productivity standards. Pag hindi sumunod yung employee, may karapatan siyang i-discipline. No? Pwede na bang tanggalin? Kung pwede, paano? Di ba? Iyan ay pag-usapan natin next week. Pero madaling salita, sa pag-discipline ng employees, it's also a part of management prerogative. Next is grant of bonuses and other benefits. Management prerogative yan. Meron tayong tinatawag na 13th month pay. No? Pag-aaralan din natin sa susunod. Iba ang 13th month sa bonus. Ang 13th month pay ay equivalent yan sa 1/12, 1/12 of the employee's total basic salary within the year. And it's given on or before December 24. No? And for that to be given, the 13th month pay, the employee must have served the company for at least 1 month during the calendar year. So halimbawa, ikaw Ang graduation kasi ngayon ano ba? Kailan ba ang graduation ngayon? June? May? July? Oh, nagpasarap ka muna. Apply ka ng trabaho bandang November. Natanggap ka December 1. Mag-i-expect ka ng 13th month pay? Hindi pwede. Kasi at least 1 month nagtrabaho ka. At least 1 month. Okay, pag-usapan natin yan. Ngayon, pwede mangyari na hindi ka entitled sa 13th month pay, bibigyan ka ng employer mo pa rin ng bonus. Oh, di ba? Hindi ka iyak. Hindi ka iyak. Pero kung hindi magbigay ng bonus yung employer mo, huwag mo mamasamain. Bakit? Management prerogative yun. Management prerogative yun. Hindi mo pwedeng idikta na wala akong 13th month pay. Hinairhire mo ko ng December tapos di mo ako bibigyan 13th month pay. Pambira ka pala. Sino ba sabi mo nag-apply ka ng November? Ba't ka ng November nag-apply? Ang tagal-tagal mo ng graduate. So, ang bonus, management prerogative. Huwag kang tatampo pagka ano. So, we still have 45 minutes. I'll try to finish as fast as I can. Page 25, clearance process. It's still management prerogative. Why? Diba? Ito yung rene-require ka na mag-submit ka muna ng clearance bago ka makawala sa company. Diba? Kasi sa company, private sa labor code, sa pribadong sektor, pag ikaw ay magre-resign, dahil kaya tayo pinapayagang mag-resign dahil nakalagay sa saligang batas yung freedom from involuntary servitude. Kung ayaw mo nang magtrabaho, kahit walang magandang, kahit walang masamang pinakita sa iyong kumpanya, napakaganda ng office, ang ganda ng sahod, pero wala ka ng time para sa boyfriend mo o sa girlfriend mo, namimiss mo na siya. Iba ang priorities mo sa life. Happiness, mental health ang importante. Happiness, okay lang yun. Pwede ka mag-resign. Anytime. Anytime. Pwede nga natanggap ka today, magre-resign ka kinabukasan. Okay lang yun. Karapatan mo yun. Pero you have to observe 30-day notice. Yung effectivity ng resignation mo, 30 days. Hindi pwedeng bigla-bigla. Yung 30-day notice, it's for the protection of the employer. So that being the protection of the employer, the latter can waive it. So halimbawa, pwede kanyang pagbigyan na less than 30 days of effectivity or hindi. Kung hindi, maximum ang 30 days. Maximum ang 30 days. Now, within that 30-day period, mayroong mga proseso. Clearance. Kahit sa PUP, nung ako ay nagtrabaho sa PUP, kinakailangan yan. Clearance. Bakit mayroong clearance? Bakit mayroong clearance process? You have to protect company assets. Baka kasi mayroong mga equipment, laptops, mobile phones, or anumang property o service vehicle na pinagkatiwala sa iyo ng company. Bago ka bigyan ng clearance, bago maging effective yung resignation mo, soli mo muna. Paano pa, Tony, pag ayaw ko, tatakbuhan ko yung clearance? Bahala ka. Okay lang. Ang problema, kaya may clearance process yan, hinuhold ng employer mo yung last pay. So, hindi bibigay ng employer mo yung last pay kung hindi mo masasettle yung clearance. Didemanda ko yan, non-payment of wages. Didemanda ko yan, anak ng pusang kinalbo. Didemanda ko yan, hindi rin. Management prerogative ang clearance processes. So, yun na nga, to protect company assets, to settle obligations. Baka meron kang mga utang sa company loan, SSS loan. Ang SSS loan po, si company mo ang nagre-remit ng payments mo dyan. So, kailangan ayusin or merong co-op sa loob ng kumpanya, kailangan isettle yung obligation. Yan. Or ano pa, kailangan din yung proper work turnover. Hindi yung mga pending mo, iiwan mo na lang sabog-sabog sa office. Huwag ganun. Huwag ganon. Kailangan yung paglilipatan mo ng trabaho, kung wala ka pang kapalit, at least yung supervisor mo or yung boss mo or yung department mo, alam nila yung pending work. Mag-turnover ka ng maayos. Huwag mong iwanang pa balagbag yung mga pending na trabaho sa'yo. Kasi masakit sa ulo ng employer yon. So kapag hindi ka sumunod sa proper turnover, which is normally documented, pwedeng tumanggi mag-issue ng clearance. At pag hindi ka in-issue ng clearance, malamang sa hindi, naka-hold yung last pay mo. Now, does that violate your right? No, that's one of the management prerogatives. Okay, again, one of the requirements, the clearance process must be necessary. It must be in good faith. It must be in good faith. No? It must be in good faith. Lahat ng management prerogatives na napag-usapan natin so far, lahat yan, walang mintes. Lahat rene-require it should be exercised in good faith by the management. Even post-employment restrictions. Ano yung mga yan? Pag sinabi mong post-employment, hindi dahil sa may poste ho dito sa picture kaya sinabi natin post-employment. Pag sinabi natin post-employment, after, merong pre, di ba merong pre-week, pre-week, before yan. Ito, post-employment restrictions. Pambihira, tapos na employment ko, may restriction pa. Oo, normal yan, management prerogative. Ano examples ng post-employment restrictions? Non-compete clauses. So ito yung mga agreements na yung dating empleyado na nagtrabaho sa kumpanya, hindi pwedeng i-compete yung business ng company. Ililipat ka, tapos i-compete mo. Ngayon, parang unreasonable. Paano kung yun talaga linya mo? Ibig sabihin, hindi ka na makakapagtrabaho. Pinapayagan ang non-compete clause pagka legitimate business interest ang pinoprotektahan. At saka it should be in good faith. At saka reasonable enough not to prevent the former employee from finding gainful employment elsewhere. Okay. So medyo mas mahirap sa part ng employee sundin ang non-compete clause. Kaya naintindihan ng batas, medyo masela ng batas sa pag-sustain, masela ng mga korte, masela ng Department of Labor sa pag-sustain, sa pagpayag sa non-compete clauses. So ano ginagawa na iba? Medyo mahirap pala ang non-compete clause. Non-solicitation clause, second kind. Non-solicitation. So dito bawal kang kukunin mo yung, aagawin mo yung customer ng kumpanya, susulutin mo yung mga empleyado ng kumpanya, customer. Non-solicitation, bawal yan. Bawal yan. Paano kung makakapag-negosyo on my own kung di ko aagawin yung mga customer ng company ko? Maghanap ka na ibang customer mo. No? Ngayon, merong mga kumpanya, whether it's non-compete or non-solicitation, nakaliligtaan nila na magpapirma sa kontrata. Dapat nasa kontrata yan. Nasa kontrata yan. Kung walang kontrata, kasi medyo burdensome ang non-solicitation, non-compete, even the confidentiality agreements, burdensome sa empleyado yan. Rine-require ng batas, although this is a post-employment restriction, it's a management prerogative, it's required by the law to be stipulated in writing. Yung labor code will not invoke this for them. The labor code requires employers to put that into writing, signed voluntarily by the employee if it is to be binding against them. Why? Because it's restrictive. It's restrictive against the employee. So while it's a management prerogative, it's restrictive to the employee, it must be stipulated beforehand by the employee in writing, before resignation at the very least. So non-solicitation, non-compete, and confidentiality agreements. So halimbawa, iba sarap ng chicken joy ng Jollibee. Isipin mo kung ikaw yung nasa planta nila. Kasi yung nasa mga stores ng Jollibee, hindi sila nagtitimpla niyan. Alam na nilang, hindi nila alam yung timpla niyan. Nandoon na yan sa, when it's sent over to them, it's already prepared. Iluluto na lang. Iluluto na lang. So halimbawa yung mga ganyan, pero nakakaalam ng recipe na yan, yung nasa loob, yung mga food tech nila. Diba? O yung timpla ng soft drinks na paborito nyo. O yung timpla ng paborito nyong inumin, yung Red Horse. Anong course? Red Horse. O diba? Diba? Yung mga ganyan. Paano tinitimpla? May karapatan ng employer na to make it a company secret. So, in the course of the employment, some employees would be able to know the company secret, the trade secret. As a result, pag sila aalis, dahil nga meron tayong freedom against involuntary servitude, the employer can require non-disclosure agreement or confidentiality agreements, bawal nilang i-disclose. Bawal i-disclose. Disclose ang bawal. Paano sir kung hindi nila i-disclose, gagamitin nila sa kalaban na kumpanya? Non-compete ang tawag doon. Guess nyo na? Sir, paano kung ayaw nilang sila ang magtitimpla, ayaw nilang sila magdi-disclose? Kukuha sila ng ibang empleyado para yun ang gagawa. Non-solicitation ang tawag doon. Okay? You follow me so far? All of these are post-employment restrictions which the employer is allowed to impose as a matter of management prerogative. But again, it must not be in bad faith. It must always be exercised in good faith. Now, you have learned some of the rights, some of the management prerogatives. A disclaimer though, it's not the rights that you've heard in this lecture, neither the management prerogatives that I have discussed to you, it's not exclusive. There may be some analogous instances. It may be a right, it may be a management prerogative. So it's not limited to those that I have mentioned. But the point is that what I wanted to say is, in having this labor law, in labor laws na to, ang pakay nito is yun nga, to protect the employee on the one hand, kasi nga mas mabigat ang employer. Pero at the end of the day, ang ideal na situation is balance ang interest ng employer on the one hand at saka ng employee on the other. Dahil lang sa entitled ng employer or as the way things are, the employer has the resources. It has to be balanced by giving the employee the protection it needs via labor laws. Those who have less in life should have more in law. And what is that justification? It's social justice. So pag sinabi kasing social justice, this was defined in that case of Kalalang versus Williams, sa mga 1940s, 1930s yan. So ito yung humanization of laws, okay? Equalization of social and economic forces. Sino mag-equalize? Ang Estado by the state, so that justice rational, ibig sabihin reasonable, objectively secular conception. Secular, walang religion, walang particular na sekta. Secular conception may at least be approximated. Bakit? We aim perfection, perfect balance. But if not, it's a work in progress. At the very least, ma-approximate ba yung equalization? So it's approximated, not necessarily 100% perfect balance. But we strive to do that. So, yun. Social justice ang lahat na ito. So kapag nag-lecture tayo sa Monday at dun pa sa makasusunod until December 9, we remind ourselves, and we do this because the purpose of the law is to achieve social justice. That is the justification for labor laws. And with that is our first lecture among 5 lectures, and still have 4 more others succeeding Mondays. Thank you. We still have, I think, 30 minutes. I was talking to Jope the other day. I told her, parang hindi ako confident na masasagad natin hanggang 4:32 ah. Sabi, hindi sir, okay lang. Basta daldal ka lang ng daldal. Matatapos mo yan. Ayun na nga, 30 minutes. Ang inisip ko nga, tapos na tayo ng mga 3:30 eh. Hindi pa pala. Ang daldal nyo! Ang daldal nyo! Kayo pa ang madaldal ngayon, di ba? So yun lang. So if you have questions, I'll do my best to answer them. Or I may, wag kayong bad trip sa akin. Maari kasing hagip yan noong mga susunod na lecture. So sabihin para hindi siya spoiler, di ba? Wag mo nang discussin ng extensively ngayon. Hapyawan natin siguro pwede, pero wag natin spoil. Wag natin spoil. Ayan. Pagod ako. Ma'am Pulma, may magtatanong po ba? May gustong magtanong? May mga tanong na sa DM. So habang ayan si Ma'am Pulma.
Hi sir, maraming salamat po. So guys, kung may tanong kayo para sa Q&A, bigay ko muna kayo kay Miss Jope para siya muna mag-facilitate ha. Okay. So magsuswap lang po kami ng place. Saglit lang ha.
Daming tanong ah. Teka.
Ayan, sir.
Backread.
Good afternoon. Thank you very much. Multitasking pa rin po tayo. Kaya napakaganda po. Para nga naman talagang nag-review ako ng Labor 1 chapter. Sir, sabi nyo
Ano?
1.5 hours pero na-enjoy nyo rin yung pag-lecture. Thank you very much po talaga.
2 oras umabat, no?
Oo nga eh. Wala lang. Parang mani-mani pa rin kay Attorney G ang pag-lecture. Lahat kami tumatawa sa
May tanong dito. Basahin natin, Jobs.
Opo. Scanin ko lang, sir.
May tanong si Miss Andrea Trilles. Sir, possible po ba na ipatupad ng isang head of office na 0 late and absent sa kanyang mga staff or minimum 3 late lang for a month? Pero wala daw sa CSC rules. Andrea, sige, CSC kasi sa government yan, pero meron tayo sagutin ko pa hapyaw yan, Andrea. Civil service kasi, ibig sabihin sa government, hindi labor code. Pero nonetheless, meron tayong 2017 revised rules for administrative cases in the civil service. Isa sa mga infraction diyan ay habitual absenteeism or tardiness, no? So yung head of agency, yung nandun sa URACS, revised URACS, andun na yun yung minimum eh. Andun yung minimum, pero hindi kagaya ng labor code, hindi pwedeng higpitan. Hindi pwedeng higpitan ng agency yan, ng government agency, ng head ng government agency, kung walang batas. Otherwise, ang mangyayari niyan, parang siya ang nag-a-amend ng batas for civil servants. Ngayon, balik tayo sa pwede bang gawin yan sa private sector? Productivity standards kasi po ang tawag dyan yung bawal mag-absent, kasi depende sa operations. Minsan talaga bawal, halimbawa, pagdating sa mga piloto, mga airlines, hindi pwedeng malilate ka madalas. Kaya hindi pwedeng nade-delay ang flight dahil late ang piloto. 'Di ba? So, it's important that the employer imposes productivity standards, and probably punctuality is among them. That's fine to maintain the quality of work, to preserve the business of the employer. However, it should not be a ground outright for termination. Kasi pag-uusapan natin later on sa private sector, hindi pwede yung unreasonable. Ang pag-terminate dapat based on just causes. Ang just causes, isa dyan ay gross negligence or habitual neglect. Ang negligence or habitual tardiness, the name speaks for itself. Kailangan gross, kailangan habitual. Kung hindi naman habitual, hindi pwedeng sibakin. So I hope I answered your question. Pero sa civil service, iba yun, ibang usapan. Sabi ko nga sa inyo, ibang patakaran sa gobyerno, ibang patakaran sa pribadong sektor. Minsan may advantage ang nasa government, minsan may advantage ang nasa pribadong sektor. Pagdating sa head of office na sinasabing 0 late and absent sa kanyang mga staff, kung civil service yan, anong consequence kapag na late or na absent? Tatanggalin mo? Bawal yan under the URACS. Hindi pwedeng agad-agad. So, iba-ibang sitwasyon. I hope I answered your question, Andrea Trilles. Yun.
Sir, mag-entertain pa po ba tayo? Meron pa pong question regarding 13-month
Sagarin natin hanggang 4:30.
Pwede daw po ba, ayon kay Rose Ann Eresmas, pwede daw po bang hatiin ang 13-month pay?
Okay. Ang basic requirement sa 13th month pay is, before ibigay yan, it should not be given later than December 24. We're speaking of, again, private sector ha. Kasi di ba sa government, mga taga-PUP Sa government, not later than November 15. Sa inyo ba lahat yan? Sa inyo ba lahat yan? Di ba? Sa private sector, ang requirement ng batas, not later than 24. Pwedeng magbigay earlier. It can be given in tranches also. But the requirement is that the amount must be at least 1/12. Total amount must be at least 1/12 of their annual salary for that calendar year. And it should not be given later than December 24. It could be given in tranches. It could be given as early as March. It could be given as early as June, mid-year, for example. Basta hindi siya later than December 24 at saka dapat yung empleyado na binibigyan ng 13-month pay nakapag-render na ng service doon sa company na yon for that calendar year for at least 1 month. Yun yung mga minimum requirements. Yun yung labor standards. Yan. Okay? Next question. Attorney, yung regular holiday na unworked po ba is counted sa computation ng 13th month pay? Yes, kasi ang factor sa yung 1/12 yung sweldo mo for the entire year. At ang matututunan nyo next time is ang holiday pay, bayad yan, nasa labor code yan. Binabayaran kayo ng employer kapag regular holidays, kagaya ng Pasko, kagaya ng Bagong Taon. Ayan. Walang pasok pero may bayad yung daily salary nyo. So, that being a daily salary, it forms part of your total compensation, total salary earned in that particular calendar year. So, kasama siya sa i-divide by 12. So, kasama siya sa computation ng 13th month. In fact, kapag ka pinagtrabaho pa nga kayo sa holiday pay, times 2. May holiday pay ka na, may premium pay ka pa. 'Di ba? So, I hope I answered your question. Kasama siya. Sa amin, yung mga, may tanong po, yung nagtanong po noon ay si Aaron Kendrick. Ngayon, meron pang tanong lipat ko nga ng screen. Naka-on pa ba yung slides ko? Hindi na, no?
Naka-on pa rin, sir, yung front.
I-stop sharing ko na lang kasi hindi ko mabasa yung hindi ko mabasa yung chat box. Maliit. Dali lang ha. Stop. How do I stop? How do I stop? Jope, paano ba mag-stop dito? Nakalimutan ko na. Paano i-stop yung screen sharing? Stop share. Ayun,
More, yun, stop sharing sa taas.
Okay na? Ano na itsura? Gallery na tayo, no? Okay. Kita-kita ka na kayo lahat. Nasaan na yung tanong? Wala. Ito next, si Maribeth Ann Tuisa. Sa amin, yung mga nagre-resign, hindi na pumapasok pagkapasa ng resignation. Okay lang yun kasi it's the 30-day notice is for the protection of the employer. The employer can choose to waive that. So the employee might not observe the 30-day notice or the employer can waive. It's not a problem. But in case the employer would enforce the 30-day notice, it should be observed, and in no case should it be more than 30 days. Okay? Not more than 30 days. How about poaching? It's also, ito naman tanong ni Pitao, JP Pitao. Poaching is also a management, anti-poaching. Yung bawal mo sulutin yung mga empleyado, bawal 'yon. So, also a management prerogative. Even after employment, pwedeng i-enforce ng employer. Siya nga pala, ito nakalimutan kong banggitin. Post-employment So, wala ng employer-employee relationship. Paano ka nga habulin ng employer mo? Dahil wala ng employer-employee relationship, ang mga bagay na yan, lilitisin na yan sa regular courts. Hindi na sa DOLE, hindi na sa NLRC. So, yung violation ng non-disclosure, non-poaching, non-solicitation, non-compete, pag binviolate siya ng empleyado, since it's a post-employment restriction, there is no more employer-employee relationship, it can be litigated before regular courts. Okay? Panganiban, David. Wow, thank you, Attorney Chris, nakakatuwa and very full. Thank you po, very full of knowledge po talaga. Thank you, my pleasure. Grace C. Katilok. Is it within an employee's right to decline answering company calls received? And I think I answered this already earlier, right? And then Diana Cielos. Attorney, I've learned, okay, thank you. I've learned a lot, especially po sa lunch breaks. Thank you, sir. Thank you. It's my pleasure. Sir, possible po ba na from Andrea patupad ng isang nasagot ko na rin ito. The rest are thank you. You're welcome. It's my pleasure. And if you have some labor concerns, you can look for Jope and ask for my contact details so we can. Okay, ano pa? Salamat po. Yes, ang dami. So attorney from Rose Ann, ask ko lang po yung basic salary po, baka ba pwede i-hold na company once resign na po. As pag nag-resign, yun yung sinasabi natin kanina na pwedeng i-hold yung last pay mo dahil yun ang pang-enforce ng clearance process. Di ba naalala nyo kanina, may clearance na requirement yung employer. So, para sa inyo clearance, pagka 30 days naman, nasagad ko na yung 30 days, malaya na ako. Totoo naman. Malaya ka na pag after 30 days dahil na-observe na yung 30-day notice. Pero, pinapayagan ng batas ang management, it's a management prerogative to hold the last pay so that it can compel the employee to observe the clearance procedure. Yun. So, yung basic salary na tinatanong ni Rose Ann, pwedeng i-hold ng company yan once nag-resign. Pero, pag na-comply na yung clearance requirements, dapat ibigay. So, yung ano yung mga i-hold? Hindi lang salary, pati yung prorata 13th month. Pwedeng i-hold ang prorata 13th month. Kasi, di ba naalala nyo, dapat not later than December 24 siya ibibigay. Paano kunwari nag-resign yung empleyado sa kalagitnaan ng taon? Nag-resign siya kunwari June or March. So, nag-serve siya from January to March, for example. That's at least 1 month. Di ba? At least 1 month for the employee to be entitled to the 13th month. And the 13th month is 1/12 of the entire earnings of that employee for that particular calendar year. So yung 1/12 na yan, no kinita niya from January to March, 13th month pay niya yon. Pero dahil nag-resign siya, dahil may 30-day notice, dahil may clearance procedure, pwedeng i-hold muna ng company yon kasabay ng kanyang basic pay. Ibibigay lang yon after ma-accomplish or ma-comply yung clearance. Okay? Daldal niya, attorney. Sir, paano po yung nabigyan ng medical certificate to work from home or hybrid setup due to medical issue pero hindi na po nahanapan ni employer po? Paano? Nabigyan ng med-cert to work from home or hybrid, okay. Pero hindi po nahanapan ni employer. O ngayon, so hindi siya nahanapan hindi nahanapan ng medical certificate. Naka-work on site pa rin po yung biyahe po sa work from Bulacan. Daily BPO po. Ang intindi ko sa tanong ni Ma'am Diana Cielos, apparently if it's a medical issue, it's temporary. So the work from home or the hybrid setup, if it's due to a medical issue, it's temporary. If it's temporary, the employer has the right to require the employee to work on site if that medical condition no longer persists. Okay? So it's still a management prerogative. Still a management prerogative. Attorney, yung minimum wage po ba required siya sa lahat ng employee kahit di po kilalang business for nagsisales po ng 4 million annual? Okay, katanong ito ni Leah Catherine. Ang minimum wage ay part ng working conditions. Isa siya sa mga chapters, titles, isa siya sa parte ng labor code. Ang working conditions like minimum wage, merong mga exclusions yan. Sino mga excluded? Managerial employees, employees working in service or retail establishment with less than 10 employees, or field personnel. Sino yung field personnel? Sila yung mga, pag field, hindi yung literal na field sa palay or sa agriculture nagtatrabaho. Sinabi nating field kasi out in the open sila nagtatrabaho, and there's no way for the employer to verify, to check their actual hours work. So normally they are excluded from the requirements of minimum wage. Iba yung payment scheme sa kanila. So to answer your question, sales yan, kung sales yan, tas field employee, nagsisale pa ng 4 million annual, maaring hindi covered yan ng minimum wage. Tanong ni Miss Leah Catherine. Direct message sa akin, kaya maaring hindi nyo nakikita sa GC. Rosel Bugal. During signal storms at baha, tama po ba na babawasan ng sahod ng isang empleyado if hindi pumasok? Okay. Depende sa scheme. Kasi meron tayo daily paid employee. Meron naman na per month. So no work, no pay. Doon sa nag-enforce ng no work, no pay, it's important for you to understand. If it's stipulated in the contract right from the start, pag no work, no pay, hindi sa dahil hindi kinakaltasan, hindi sa dahil kinakaltasan. Wala ka lang talagang susweldohin dahil di ka nagtrabaho. Yun. Pero yung mga fixed ang monthly salary, no? Depende rin sa employment contract nyo yun. Pag hindi ka pumasok dahil may bagyo, ano ba nakalagay sa employment contract? Kakaltasan ka ba or hindi? Kasi yun yung tinatawag na may kaltas. Pero take note yun ay sa mga bagyo lang. Kasi under the labor code, ang mga special holiday, regular holiday, pag special, walang bawas, walang kaltas. Pag regular holiday, pag hindi nyo pinasukan yan, dahil nga holiday yan, may sweldo pa rin kayo for that day. Okay? Anong nagtanong ng si Rosel D. Bugal? Laika Ornos. Ano po yung cut-off ng 13th month? Ayun, cut-off ng 13th month is at least 1 month nagtrabaho yung employee dun sa pagbibigay ng 13th month. At saka dapat ibigay yung 13th month not later than December 24. At saka yung 13th month pay are equivalent to 1/12. So kung magkano yung sinweldo mo ng buong taon kasama ang holiday pay, service incentive leave, kung namo-monetize yan, divided by 12. Yun ang 13th month. Okay? Ngayon, ito tax to. Kapag lumagpas ang 13th month mo ng 90,000, meron na ba sa inyong lumalagpas na ng 90,000 ng 13th month? Ibig sabihin, mga 90,000 na sweldo. Walang umaamin. Subject to tax yung over and above 90,000. Subject to tax yun. So, wag niyong awayin yung employer niyo pag nagkaltasan yung 13th month pay niyo. Dati tax-free yan. Pero doon sa amendment ng National Internal Revenue Code sa train law, over and above 90,000 subject to tax. Attorney, tanong ni Maribeth Ann Tuiza. De Luna. Charlene May De Luna. Kita. Charlene, on mo yung video mo. De Luna. May ribbon ka pang pula sa buhok. Ang tanong niya, what about po hindi matanggap sa work because of tattoos? Discrimination. Depende. Is it a bona fide occupational qualification? Right? Depende kung kailangan siya sa trabaho. Kung kailangan ba siya na kailangan walang discolored skin yung sa work, no? But if it's not, it's the same principle Kagaya naming mga pangit, kung ang trabaho ay trabahong abogado, trabahong accounting, yung mga pangit kagaya ko, hindi dapat rene-reject yan. Di ba? Yung kayo, swerte kayo, magaganda at mga gwapo kayo, kaya hindi nyo pinoproblema yung mga ganyan. Kami, mga pangit. Di ba? Ayun. I hope I answered your question. Medyo mahirap sagutin kasi depende sa klase ng trabaho yon, Charlene. Kung bona fide occupational qualification. Nagre-raise ng hand si BSBA Kangayo. Are you raising your hand?
Yes, sir. Yes po,
Sige,
attorney.
sige. Sige.
Question lang po. Kasi solo parent po kasi ako, sir. So, sa DOLE handbook po is nakalagay na 6 months above, entitled ka na sa 7 days solo parent leave. So, dito po sa current work ko, sir, almost 1 year na ako, magwa 1 year this January. Kinancel nila, sir, yung ano ko, yung 7 days leave ko. Hindi nila binigay sa akin. Tapos tinanong ko si HR namin, ang sabi niya, sir, dahil daw po sa company policy, na dapat 1 year ka na muna nag-work dito bago nila ibibigay yung
Pero 1 year ka na ba?
Sa January, sir. Pero nag 6 months kasi ako, sir, nitong July.
Ang pagkakaalala ko sa solo parent leave, na it's one of social legislation measures. It's not, you have to apply You have to declare na solo parent ka
Yes, sir. May
With all
po
the
ako.
requirements.
Opo, meron po ako, sir. Pinasa ko po sa kanila.
Malaking company po ba yan?
Opo, medyo po. Sa PCCR po.
Saan?
Philippine College of Criminology.
Then naririnig nila ako nagle-lecture o naka-earphone ka dyan. Kasi sabi ko na yung mga benefits baka...
Naka-earphone po.
I-check mo muna, go over mo. Baka merong part sa'yo, na-consume mo na ba yung leave? Check mo muna on your end, from your end, kompleto ka ba sa lahat ng requirements? And then, if it's not, you're talking about 7 days lang per annum. And then you just started with them. Here's the thing that you have to consider. Do you want to enforce it? In which case, you have to go to the Department of Labor. No, it's your right. It's your right. Or, before you going to the Department of Labor, perhaps medyo may pagkakamali lang si HR. Baka pwedeng you could politely, courteously inform the HR, no, ma'am, these are the requirements. I complied with all of them. I think I'm entitled to i-ano mo lang muna. Lahat naman madadala sa diplomasya mo na sa simula Pagka hindi pa rin, hanapin mo si Jope at saka si Ma'am Pulma. Try namin i-assist yung ikaw. Okay? Try natin i-assist.
Thank you po, attorney. Kasi nakausap ko na po yung HR head po namin, attorney, regarding dyan. Lahat po ng requirements, binigay ko naman po. Pero, kasi after 6 months po, binibigyan kami dito, sir, ng 5 days. SL at BL.
Ano yung 5 days na binibigay?
SL tsaka BL po.
Sick leave, vacation leave.
Opo.
5 days.
Opo.
Yan yung equivalent to service incentive leave na 10 days Pero binibigay yun actually binibigay yun pagka naka-render ka na ng at least 1 year. Ikaw kamo 6 months. Kaya siguro gano'n. Kasi, kumbaga, naging lenient sa'yo sila. Ang service incentive leave na 10 days ay pwede lamang mapakinabangan ng isang empleyado na 1 taon nang nagtatrabaho. Pero in your case, 6 months ka pa lang, pero binigay nila. Di ba?
Opo, yun po yung company policy.
Ginamit mo ba?
Opo. Kasi hindi po nila ibinigay kasi, sir, yung solo parent.
Baka lang i-compute mo. So if you're less than 1 year, but you still enjoyed 10 days of sick leave and vacation leave, which actually is ang mandatory is service incentive leave. So in cases where the employer provided already for sick leave and vacation leave, a total of 10 days, that's already substantial compliance with the minimum requirement ng batas ng 10 days na service incentive. Pero take note, 6 months ka pa lang. Baka siguro dun hinugot, dahil binigay ka na ng 10, baka doon nila hinugot yung pang solo parent mo. Pero tignan natin na maigi. I-go over natin. Pagka may mali pa din, Hanapin mo kami kay Jope, ha?
Thank you po, attorney. Thank
May nagre-raise ng hand pa. Sige, it's already 4:25. Still have time for probably 2 or 3 more questions. The Joy Morales raised her hand. And then there was someone also raising her hand earlier. Sino yung nauna? Si ma'am? Sino yung nauna? Oh, tumahimik. Oh, magbabasa na akong tanong. Magbabasa na ako.
Sir, magbasa ka na lang po kung natakot lang.
Magbabasa na ako. Oh, sige, hindi na ako papawat. Magbabasa na ako. Sige. How about naman po sa service charge? Kasama pa rin po ba ang upper management? Inamend na yan ng panahon 2019 ba? 2018 or 2017? Inamend na service charge, 100% service charge dapat sa employees na yan. Inamend na yung batas. So, i-discuss natin yan sa next yung service charge. Part yan ng salary. Part yan ng benefits, salaries, benefits, condition of work. Okay. Ito si Prosit, taga BSBA HRM. Prosit. Nakikita nila, hala kay Rosit pa lang binabasa, 26 mahigit pa tayong nagtatanong, hindi natin masasagot lahat ni attorney ito. Mamili, anong gusto nyo next time? Tapusin, alas 2 pa lang, tapusin na natin alas 3. Magsasagot na lang ako. Question, paano po kung tumagal ka sa company for almost 18 years, wala naman pong nagawang violation sa employee? If ever na mag-resign na si employee, entitled po ba si employee ng kabayaran mula? You're referring to separation pay if you're asking kung may separation pay ba pag nag-resign? Or kailangan talaga antayin till retirement? Okay, it depends. General rule under the labor code, minimum requirements minimum requirements. Pag nag-resign ka, you're not entitled to separation pay. Minimum yon. Minimum requirements, labor standard. But in certain companies, they offer something better. Dahil minimum lang yun eh. So, meron silang pool na nagkakalta sila sa salary mo or sila nagde-deposit sila sa parang trust fund for the benefit of the employees. Depende sa tagal ng empleyado, lumalaki yung savings na inuhuhulog ng kumpanya or ng employee or both of them. Pag merong ganon, entitled ka doon sa payment, sa lump sum benefit na yan or pwedeng in tranches when you resign. Kung merong ganong benefit. Kung wala, ang labor standards natin, minimum requirements is separation pay is only given in case of authorized causes for dismissal, like installation of labor-saving device or redundancy, or in case of illegal dismissal, or in case of retirement. But if it's voluntary resignation, again, to emphasize, if it's voluntary resignation, labor standards sa minimum requirements, in the absence of benefits to the contrary, hindi siya binabayaran ng separation pay, Rosie. Kaya wag ka munang magre-resign agad. BSBA ka pa naman eh. So nag-aaral ka pa. Okay? Si Tatel, last na to. Ask ko lang po yung leave without pay or absence. Ganito. Itatanong niya, yung leave without pay or absence, leave of absence, ibabawas din po sa computation ng 13th month pay? O may question mark siyang ganun. 13th month pay? Kasi pag period, ibabawas din po sa computation ng 13th month pay. Sinasabi niya. Pero ito pa tanong, ibabawas po ba to sa computation ng 13th month pay? Ang sagot, hindi binabawas. Ang formula ng 13th month pay is kung magkano yung kinita mo, magkano yung salary mo for the entire 1-year calendar, you divide that by 12, that's your 13th month. So, walang kinakaltas. Ayun. So, eto, totoong to, last na to. Si Santa Mesa, Bakuli, Miss Bakuli, hindi ko makita yung buong pangalan. Hello, partner, pwede po bang converted, offset na lang ang OT? matututunan natin yan. Pwede bang offset na lang ang OT sa mga private company, hindi na-offset ang overtime pay ng tardiness and vice versa? Kung overtime ka. So halimbawa, ang pasok mo ay 8 a.m. to 5 p.m. Dumating ka, dahil pasaway ka, dumating ka alas 11. Okay? Ginawa mo, dahil medyo nahiya ka sa employer mo, buti nahiya ka, putya. Nahiya ka sa employer mo, sinagad mo hanggang, kinumpleto mo yung 8 hours. Kinumpleto mo yung 8 hours. Entitled ka technically sa overtime pay. Kahit alam mong nahihiya kang tumanggap ng overtime pay dahil alas 11 kang pumasok at nahiya kang tumanggap ng overtime pay. Entitled ka. Entitled ka. No, hindi offset, walang offsetting, walang ganun. Walang ganun. So ibig sabihin, kapag ikaw ay pumasok ng alas 11 at willing to waive ka ng overtime pay, kakatusan ka pa rin ng HR. Sabihin, obligado kami magbayad ng OT mo eh. Kapag lumagpas ka ng alas 5, anong nagmamagandang loob? Pumasok ka ng maaga kung gusto mong magbagandang loob, huwag ka pumasok ng alas 11. Yun. Walang offset, walang offset. So, yun ang huling tanong dahil 4:30 na ang TV na. Si Berna Kagomok may
Berna Kagomok.
sige, last.
Apo,
Sige,
mukhang
last.
Yes, Miss Berna?
Yes, sir. O, patanong ko lang, halimbawa lang Diba, may way back
Ayoko, halimbawa, asking for a friend. Joke lang. Sige, go ahead.
way back 2010. Tapos hanggang 2014, nag-work ako sa isang private company. Since under agency ako, hindi sila naging transparent. Nakita ko na wala silang, kinakaltasan nila ako, pero wala ang hinuhulog pala. Mahabol ko pa rin siya kahit ngayong taon na to. Sobrang tagal naman, 2010 to 2014 o 2013.
Okay. Pag-uusapan natin yan sa minimum wage, no? Yung independent contractor, di ba? Saka yung labor-only contractor. Pero kapag ka non-payment of monetary claims, di ba? Pag kasi ganyan, yung agency ang direct employer mo. Yung kliyente niya, kung saan ka dinedeploy, yun na ang indirect employer. Okay? Sundan mo so far? Okay? Example niyan yung ating mga security guards. Ang employer ng security guard, yung agency. Ang indirect employer ng security guard, yung saan dinedeploy siya para magbantay. Okay? Sa labor code, pag legit yung contractor, yung agency, tawag doon, independent contractor, yung kliyente, indirect employer. Ang sabi sa labor code, pagdating sa mga sahod, monetary claim, ang liability, o may BSBA na to, nag-obligations and contracts kayo, alam nyo ang joint and solidary. Ang liability sa monetary claims ng agency at saka ng indirect employer ay joint and solidary. So, ibig sabihin, pag hindi nabayaran in full ng agency yung kanyang wage deficiency, ang mananagot doon, si indirect employer and/or si agency. Joint and solidary sila. But still, it does not prejudice or does not preclude the indirect employer from going after the agency to collect the balance, to collect the payment. Kasi ang may obligasyon na magbayad talaga na sa agency, di ba? Pero for the protection of the employee, requires the indirect employer to be jointly and solidary liable for the deficiency. But again, subject to this right to be reimbursed. Now, it's a monetary claim. It prescribes in 3 years. Ano ibig sabihin ng prescription? O BSBA, Business Administration, nag-oblicon kayo. Prescription. Napapasu yung claim. 2014 ka. 2024 na ngayon. 10 taon na yan. Paso na yan. Hindi mo na mahabol. Did I answer your question? Nasad ka ba?
Sobrang sad, sir.
Okay.
Okay. Sabi ko na, sir, sa'yo, aabutin ka ng medyo matagal dahil labor to. Ayan.
Oh,
So, ang sayang discussion natin, guys, meron pa kayong additional 4 days. So, standby lang kayo. Marami kayong matututunan kay attorney. Next week, meron uli siya pong lecture. Another week, hanggang December tayo. So, at least, di ba, comprehensive talaga siya. So, maraming salamat, sir.
maraming salamat. In return, this is a labor of love. In return, huwag niyo kakalimutan yung pangalan ng party list ko. Peace. Sige. See you again next Monday.
Yes, we'll be seeing you guys again next Monday po. Maraming salamat, Sir Garganchel. Actually, Sir Eric, yung certificate of appreciation nyo will be on the last day po.
Yeah, it's
Para
fine.
isang buong ano siya. So, i-award ko po yan sa inyo on your last day of talk po. Sa lahat po, guys, marami ba kayong natutunan? Pa-thumbs up naman sa attorney or pa-heart.
Sige, maraming salamat. It's my pleasure. It's my pleasure. See you again next Monday.
Thank you, attorney. Ingat.
Enjoy na enjoy ang lahat.
attorney.
Siyempre, hindi lang yung nasa Zoom natin ang nag-i-enjoy, pati yung ating nasa live sa Facebook. So guys, kung gusto nyong maging updated, paki-follow naman po at paki-like ang PUP Career Center Facebook page. And again, maraming salamat, Attorney Chris. At pinagbigyan nyo ang aming mga kais po at kaiska. So guys, ang dami nyong natutunan at sana makatulong ito sa inyo. Diba?
Thank you very much. I'll see you on Monday. Goodbye.
Okay, maraming salamat po. At ito na po ang ating PUP hymn.
Ang ikang taglay, PUP, aming